I declare open this public hearing of the Parliamentary Joint Committee on the Australian Commission for Law Enforcement Integrity for its inquiry into the expansion of the Australian Commission for Law Enforcement Integrity's, ACLI, jurisdiction and the corruption vulnerabilities of law enforcement agencies' contracted services. The committee's proceedings today will follow the program as circulated. These are public proceedings being broadcast live via the web and in Parliament House. The committee prefers evidence to be given in public, but under the Senate's resolutions, witnesses have the right to request to be heard in confidence, described as being in camera. It is important that witnesses give the committee notice if they intend to ask to give evidence in camera. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to the committee. I remind committee members and officers that the Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits any questions asking for opinions on matter of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. A witness called to answer a question for the first time should state their full name and the capacity in which they appear to assist Hansard to record proceedings. With the formalities over, I welcome everyone here today. In addition to myself, we have the following members participating. Understand Mr. Zapier, Mr. Antic, and Mr. Laming. Is that correct, Secretary?
Mr. Zapier and Senator Antic are on the line. Mr. Laming isn't at this point.
Oh, not at this point. Okay. Thank you for that. It's difficult to know. I'll lead out with some questions. I'd like to know about the agency's interactions with ACLI in the lead up to and after the expansion of ACLI's jurisdiction. And from your perspective, what lessons can be learned from ACLI's jurisdictional expansion?
Janine Clark, Assistant Commissioner, Fraud Prevention and Internal Investigations. Chair, we had several meetings with our colleagues at ACLI when it was announced that we would be coming into jurisdiction under regulation. So we met with them and talked about what processes and procedures we would need to put in place in order that we meet our obligations under the Leak Act. Since coming under jurisdiction, we meet regularly with our colleagues at ACLI. The Commissioner meets with the Integrity Commissioner very regularly, and at the SES level we have counterparts at ACLI where we meet and discuss any of the issues or the referrals that we might have, and operationally our investigators meet with ACLI on a day-to-day basis. We currently have 5 joint investigations with ACLI, which means that investigators from the ATO work hand in hand with ACLI to investigate the allegations that have been raised.
What assistance or support did your agency receive from ACLI regarding the expansion?
So the assistance we received was to sit down and work out what would be required of us to give us. We attended a couple of workshops on how the Leak Act worked, how the law enforcement function test worked, what constituted corruption under the Leak Act. We did some test case studies in those workshops to give the ATO a better idea of who within the organisation would fall into jurisdiction. We had several meetings prior to that, and there's been an open door policy if we ever have any issues to raise, to work with our colleagues at ACLEI to resolve those.
Has participating in ACLEI's community of practice for corruption prevention benefited your agency?
Yeah, we're very active participants in that community of practice. We've presented there on a number of occasions, and we've also obviously been able to listen to and learn from presentations from other agencies that fall into jurisdiction. That allows us all to talk through things and work out what's best practice, and as a result of that, sometimes we might tweak a procedure within our own organisation, so we believe it's been a great benefit to us, and as I said, we're active participants.
An interest of this particular inquiry is the potential expansion of ACLEI's jurisdiction, particularly in relation to contractors. So I'm just interested in what proportion of your workforce is included in ACLEI's jurisdiction, and maybe a bit of background around your sort of outsourcing requirements, if any.
So, of the 20,000 or so ATO staff, we believe that probably only 1,000 staff fall cleanly into jurisdiction, so that would be staff in our integrated compliance area. Other staff, obviously, we assess as the allegations come in to see whether they meet the law enforcement test. In terms of our outsource capability, most of the outsourced contractors are employed to do surge work and other work for our call centres, so we're fairly confident that very few, if any, would fall under ACLEI jurisdiction.
We've had some evidence that the law enforcement test has delayed easy referrals to ACLEI. Is that been your experience to date?
We have had some experience of that. So of the 12 referrals that we've made to ACLEI, 3 were unable to be easily determined as to being in jurisdiction in terms of applying the law enforcement test. Those ones ACLEI referred off to the Australian Government Solicitor. So that has, and it continues to be a challenge, but what I can say is that we assess all of our allegations as they come into a single front door for corruption and for the law enforcement test. And we're relatively cautious in that if we think anything might fall into jurisdiction, we refer it on.
Have you formed a view on whether the law enforcement test benefits you? I ask from the perspective of it's a narrowing of the scope, which is obviously a policy position, but there has been some evidence from agencies that, and maybe because of the particular segment in the public sector they're in, that they would prefer that removed and ACLEI have jurisdiction over all their employees.
Administratively, it would be easier if we didn't have to apply the law enforcement function test.
If they're not in ACLEI's jurisdiction, you handle them obviously with your own under your own integrity framework.
Yes, that's correct. So a matter is assessed. So as I said, we have a single front door. All the allegations are assessed. If they determine not to be within ACLEI's jurisdiction, then they're triaged. Some of those matters will be management matters around people or HR issues, but some of them might also be criminal allegations, and we have our own criminal investigations team. Others might be breaches of the ATS Code of Conduct, and they're handled by our ATO people team responsible for breaches of the ATS Code of Conduct.
But I might just hand over to Mr. Zapier.
Thank you, Chair. Can you hear me okay?
Yes, we can.
Yeah, well, I can hear you.
Okay,
Yep.
thank you. Thank you for those answers. Can I just go back to the 5 matters that are currently under joint investigation? If ACLEI had no oversight of those matters, what would have been the normal course for the ATO to investigate those matters?
I might ask my colleague, Luke O'Connor, who's the Director of Investigations, to answer that.
Thank you. Yeah. Luke O'Connor, Director of Investigations. If matters weren't referred to ACLEI, as was previously said, we conduct an assessment to determine whether or not the allegation should be investigated to a criminal standard. In those circumstances, we have a team of investigators who are experienced in criminal investigations, and in some instances we will partner up with law enforcement agencies, be it state or federal, to undertake those investigations. Where we don't require law enforcement powers, for instance search warrant powers, we will undertake those investigations ourselves, gather the evidence to a criminal standard, prepare a brief of evidence and refer that to the Commonwealth Director of Public Prosecutions for assessment.
So if that is the case, what value has ACLEI added to your investigations?
At the operational level, I think ACLEI has been able to provide us with support in the form of the joint investigations. ACLEI obviously have a raft of investigative powers that we don't, and so when we're undertaking joint investigations with ACLEI, we have access to those powers, which certainly assist the serious corruption investigations.
In the past, have there been occasions which, in your view, were not prosecuted because you didn't have those powers?
No, I couldn't say that. In the past, we would investigate jointly with, as I said, other law enforcement agencies. However, it's probably fair to say that ACLEI's focus on corruption issues and the requirement for us to notify corruption issues to ACLEI ensures that we get support in those styles of investigations. Occasionally, in the past, law enforcement agencies may not be in a position to be able to resource investigations in support of some of our matters that may not reach their threshold, of criminality, I guess.
Yeah, no, I appreciate that. I'm just trying to ascertain what value ACLEI will be to the ATO in the future with respect to investigating these matters. And I appreciate that ACLEI has additional powers, but I guess I'm trying to ascertain whether if ACLEI wasn't around and didn't have oversight, would some of these matters not ever be pursued?
No, Senator, I think all matters that, raise a corruption issue, even prior to ACLEI, required investigation, and we have a responsibility to investigate corruption issues. So, where necessary, we would undertake those jointly with law enforcement.
So, with respect to the 5 matters that are currently being jointly investigated, are you able to tell the committee the nature of those investigations? I don't ask for specific details, but I'm just trying to get my head around the sorts of things that you might be investigating.
Sure. I'd say the types of referrals today, generally speaking, range from allegations of bribery, fraudulent claims, unauthorised access and unauthorised disclosure of information.
In the past, has there been successful prosecutions over recent years with respect to matters that would be similar to the ones that you're now referring to?
Yes, as recently as I think December last year, we had a matter that was resulted in a plea of guilty in I believe the Brisbane District Court in relation to fraudulent offences.
And was that investigation carried out solely by the ATO, or did it include other law enforcement agencies?
That particular investigation was undertaken by the ATO alone.
Chair, I think that's about it for the time being. Thank you.
Thanks, Mr. Zapier. I've just got a couple more questions. Given your evidence was that given your total staff numbers, it's only a small amount in considered in relation to law enforcement. Has that meant that basically you haven't needed to change your internal procedures, given the large majority of your employees or those associated or servicing the ATO are not within the jurisdiction? I don't ask in a negative sense. I'm just trying to gauge how much you've had to change to integrate ACLI into your practices and procedures.
So we have made some changes to our practices and procedures, one of which is instigating a mailbox which we call Speak Up, and that's our one front door. So the idea behind that is it gives us visibility of any and all allegations that staff or others may want to make to us. And then we triage those to see whether or not they are for ACLI. Doing joint investigations with ACLI has also changed some of our investigative procedures. So the team has worked very closely with ACLI on those joint investigations, and we get tasked by ACLI to help with those investigations. So, we have the access, obviously, to the records within the organisation. We do that work on behalf of ACLI. So we have made some changes with 5 investigations currently running. That has been quite resource intensive. But that's not to say that wouldn't be the case if we were doing it with another law enforcement agency.
Yes. Have you completed a corruption risk profile for the agency, and has it been shared with ACLI?
Yes, so we had an independent assessment of our corruption risk profile in 2017 by Professor David Lacey, and that has been shared with ACLI recently.
Do your anti-corruption approaches target the areas of highest corruption risk? Is that how you approach your anti-corruption strategies, or you do take a broader approach?
We take quite a broad approach. The ATO prides itself on a very strong integrity culture, so we do take quite a broad approach. We're very conscious of the fact that we hold some very sensitive and private data of taxpayers, and so we put in place a lot of procedures and controls around that, as well as mandating training so that staff are aware of their obligations, and communication and awareness campaigns to ensure that we're protecting that data.
Has the ATO formed a view whether it's got sufficient integrity powers, whether internally or in respect of its relationship with ACLI? Or would you, if it was to be reviewed, since we are undertaking a review, would it be your wish that consideration be given to expanding ACLI's jurisdiction?
I'm sorry, Senator, I missed the end of that question.
Well, my question's really around, has the ATO or yourselves formed a view whether you have sufficient integrity powers? I'm sort of building on what Mr. Zapier had line of questioning. Have you formed the view that you have sufficient powers to prevent, identify and investigate and respond to corrupt conduct? Would you have a wish list of maybe more power or a broader relationship with ACLI?
Look, as APS investigators, in effect we have no powers. So we are heavily reliant upon ACLI and other law enforcement agencies to assist our investigations, and I think that works. You know, I think that works well.
I see this letter. Oh, that's yours.
Does any other committee member have any questions?
Chair, I've got one other, if that's okay.
Yeah, absolutely. We have time.
Just going back to the question of ATO investigations, in light of ACLI now pursuing or jointly working with the ATO on those investigations, will that mean that in the future the ATO's own investigative branch might be scaled down, and is it likely that there will be redundancies within that branch?
Look, no, I don't think so. The joint investigations with ACLI are quite resource intensive at the ATO side. Inherently, with a corruption allegation, the evidence will lie within the ATO. So the specialised ability to access our own internal systems, understand the workings of the ATO are all, I think, skill sets that ACLI would require of the ATO to assist these investigations.
And just on that, and you referred to the word skill sets, are the skill sets of the current ATO investigative team skill sets that arise from people who had previously worked in criminal prosecutions?
Yes, we have a mixed skill set. Primarily, our investigators either come from a law enforcement background or they come from a tax background, and we think that is a good blend for the style of work that we do.
Okay. All right. Thank you, Chair.
We've had Mr. Laming join us. Can you hear us, Mr. Laming?
All good. Thank you, Chair.
That's all right. Does any other member have any further questions? Otherwise, I'll release the witnesses. Well, thank you for your participation this morning.
Thank you.
Thank you.
And you're released.
Thank you. Bye-bye.
And Chair, we're just waiting for ASIC to join us. They should be ready in just a moment.
Thank you.
So, Chair, I can see both Mr. Day and Mr. Gurdon from ASIC are with us and ready to go when you are.
Thank you.
And sorry, I should add they're on video conference.
I now welcome representatives from the Australian Securities Investment Commission via video conference. Mr. Warren Day Chief Operating Officer, and Mr. Zach Gurdon, Chief Risk Officer. Thank you for speaking with the committee today. The committee has a copy of your submission. For the Hansard record, can you please state your full name and capacity in which you appear at the hearing? And I then invite you to make an opening statement if you choose.
Thank you, Chair. My name is Warren Day. I'm the Chief Operating Officer at ASIC.
And thanks, Chair. Zach Gurdon, Chief Risk Officer at ASIC.
Do you have any opening statement or any opening comments you'd like to make?
I have an opening statement if I could have the committee's indulgence, Chair.
Yeah, thank you.
Thank you, Chair. As I said, my name is Warren Day. I'm ASIC's Chief Operating Officer, and with me, at least virtually, is my colleague, Mr. Zach Gurdon, ASIC's Chief Risk Officer. Together, we appear for the Commission today. As you will know, since the 1st of January 2021, ASIC, along with the ATO, APRA and the ACCC, is within the jurisdiction of the Australian Commission for Law Enforcement Integrity, ACLI. ASIC senior executives, in consultation with ACLI, have established protocols for how ACLI should be notified of corruption issues related to ASIC's law enforcement activities to comply with the obligations of the LEIC Act. We have worked closely with the ACLEI and the Integrity Commissioner, Commissioner Jala Hinchcliffe, and in fact have had the opportunity for Commissioner Hinchcliffe to speak to our commissioners and senior executives at an internal ASIC forum in December 2020, just prior to ACLI's jurisdiction over ASIC's enforcement activities commencing. In relation to ASIC's internal protocols to meet our obligations, the Chief Risk Officer oversights these protocols through ASIC's ACLEI notification procedures, which include ASIC's internal Integrity Committee, supporting the Chair on matters that may require notification to ACLI. Further, ASIC has established both formal and informal liaisons with ACLI. ASIC's Chief Risk Officer and Commission Counsel attend a monthly standing meeting with our dedicated contacts at senior operational and executive levels of ACLI, while ASIC's Chair and the Integrity Commissioner also meet periodically. We have open lines of communication and access to senior operational and executive staff at ACLI to get advice when matters come to light or to respond to requests or questions. ASIC's principal investigation team members across our security and integrity and professional standards unit attend ACLI's community of practice on a quarterly basis. Accordingly, we believe since the commencement of ACLI's oversight of ASIC in January 2021, and given the efforts I've just covered, we have developed a strong working relationship and platform between our agencies to ensure our response to possible corruption issues is effective and timely. We will continue to work collaboratively with ACLI and explore how we can enhance our own corruption prevention practices. I just wanted to speak briefly on the notifications made by ASIC. From the 1st of January 2021 to the 15th of February this year, 6 matters have been formally notified to ACLI by ASIC. This includes 3 additional notifications since submissions were published. We also note that ACLI has also received referrals from other sources, including members of the public. While there have been some minor delays caused by issues of interpretation of the LEIC Act and the complexity of the matters referred, as both ASIC and ACLI grapple with the new processes, ASIC has not experienced any lengthy delays in processing notifications. ASIC has not been the subject of any ACLI-led or joint investigations to date, and therefore cannot comment on the length of time taken or any delays in respect of such processes. Chair, with that overview concluded, we're here to assist the committee with any questions you may have.
Chair, sorry, I think you're on mute.
Yeah, my apologies. With that overview in mind, we are interested in your agency's interactions. So if you could put a little bit of flesh to that bone with ACLI in the lead up to and after the expansion of the jurisdiction.
Yes.
And from your perspective, what lessons can be learned from ACLI's jurisdictional expansion from your perspective?
It's a good question, Chair. I might lead off and then I'll hand to my colleague, Mr. Gurdon. We did a large amount of work. ASIC had already been moving down the path of and had created what we call internally our Integrity Committee. So our focus in that integrity committee was to bring our activities from varying parts of our security, risk, compliance, people and development, and professional standards unit together, operations and our chief legal counsel as well, so that we could look at what the integrity issues across ASIC were, so that we could both improve as an agency, improve our controls, but also obviously properly handle those matters that were being raised or had concerns about. Through that process, and obviously at the same time as the ACLEI jurisdiction increased, we obviously engaged with the ACLEI and with Commissioner Hinchcliffe directly. And I must say, Commissioner Hinchcliffe and her staff and her people were very keen to engage with us. And we obviously learned a lot through those discussions about what would work for an agency of our size and nature compared to the ones that she was dealing with before. Obviously, there are differences in the agencies that she had oversight before compared to the agencies that she's now got. If you like, there's a more commercial activity in what we do, and there's a wider set of activities in what ASIC does than, if you like, just pure law enforcement. Although we believe the amount of activities that ASIC staff are involved with potentially would cover 67 to 68% of ASIC staff and their work, in relation to the jurisdiction of ACLEI. But there's still a lot of stuff that ASIC does, that would not fall into the jurisdiction as a result of what their operational activities are. So early conversations are really about making that distinction so that the ACLEI could get comfortable and understand what ASIC's focus is and ASIC's activities are, for the purposes of ensuring the right relationship, but also that the right matters are covered. And that's something that I think we're continually talking to each other about, to have a good conversation so that we can distinguish those things that do fall within the ACLEI's jurisdiction and those things that don't. And as I mentioned, the stand-up meetings, the interagency discussions really help in flesh that out. And what it also does through the other meetings that the ACLEI does is effectively create a community of practice between us and those other like agencies like APRA, the ACCC and the ATO, about the types of issues that we face that might be particular to our agencies compared to other more pure, if I can use that phrase, pure law enforcement agencies. So, the relationship has been very much about a learning approach, certainly prior to the jurisdiction commencing, but obviously that has continued since, because again, they are learning what's the difference between, again, those pure law enforcement agencies and ours, which are more commercially focused. So those learning activities continue. I might pass it to Mr. Gurdon for any further comments.
I think Mr. Day's covered off probably what are the key points. I think the relationship, and one of the key things operating with ACLEI is being regular and frequent in our interactions. So even though we might meet monthly, we'll regularly pick up the phone and have a conversation around questions or other concerns that might come up. So I think that's an important aspect to the relationship. We've designed our internal corruption, anti-corruption fraud framework to cover all relevant issues that might emerge, whether it's related to law enforcement activities or otherwise. So there's a sort of a seamless operation of that framework. That means that matters that do get raised are all treated equally the same, although in this case here we have a sort of a notification to ACLEI. So that keeps simplicity and consistency in terms of what incidents do need to get notified. And then we also regularly share our own insights and procedures and documents sort of in the interagency too, so that information sharing component is particularly important to us. So we've used ACLEI, their corruption prevention unit materials, and spoken to their team members as well, and they've helped us with some of the design of our internal risk management activities. So we lean on that where we can. So I think the overarching message there for us is that we try to be as frequent and collaborative and open as we can, just to make sure that we're learning as we go, because there have been some challenges in interpretation of the LEA Act and how it applies to our work. So it's been important to do that, that regular interaction.
Just, there are sort of 2 points I want to pick up on. One is, well, actually they're related, but the proportion, I think you said about 60%, there was some evidence are under ACLE's jurisdiction. And we've also, Mr. Gurdon mentioned sort of the law enforcement test, I think. Do you have any comments on how that's working? We've had some evidence that it slowed the process down. Obviously, you haven't made a referral yet, but you may have had some considerations regarding whether to make a referral. Would it be better for your organisation to have a cleaner distinction, or ACLE covering all of you? Or is it too early to form that view?
If I might lead off, Chair. You know, I think you have to acknowledge that the law enforcement activity limit, the jurisdictional threshold test under the Act, is challenging for those of us who are the new agencies. You know, as I say, because our functions are broader than law enforcement in terms of what we do, in terms of providing regulatory guidance and other things that we do, such as say our licensing functions and those type. As I said, just to be clear, when we look across our staff group, and we're an agency of about 2,200 people, when we look at the functions across our 6 activities, we estimate roughly, as I said, about 67 to 68% of our staff may fall into this jurisdiction by virtue of what those core operational activities are. But each case is going to be subject, to interpretation. And in fact, part of that is we will discuss with the ACLEI our view of what the relevant staff members' activities are and whether that falls into it. And that is working quite well so far. Would another test be better? I've got to say, from where I sit, although Mr. Gurdon may have a different view, I'm not so sure about that. I think, law enforcement activity, I think, is enough for us to work with. And I would think whichever phrase or choice or definition you would use, it's going to run into some challenges. We see ourselves as a law enforcement agency in the main in terms of what we do at ASIC. So, we probably are in a better place than potentially organisations such as APRA in making that distinction. But, we are learning, as I say, we are a learning organisation, and we are learning through this process. So where I stand, at least, and I think where ASIC stands at the moment, is that the definition is workable and it probably needs a little bit more time. So, I mean, if we were to have this discussion in, say, another year's time, we may have had some water under the bridge so that we could make a different conclusion. But where it stands at the moment, I think the definition is certainly workable. The nature of our relationship with ACLE means that we can decide and agree whether we think that's appropriate, the matter at hand is appropriately falling under that test. Mr. Gurdon?
I think the notifications progressively have got easier over time, in the sense that we understand what matters need to be referred, and there is some additional overhead in terms of preparing materials for those notifications, which is completely to be expected. So I think, to Mr. Day's point, more time will show whether or not how easier it will get. But I think the coverage that we have is sufficient, and the processes that we're using, and as ACLE themselves learn what is relevant and different to the way our mandate and our priorities are and the types of conduct work that we do, then their determinations will get easier for them. And so, we've had some relatively minor, we've had some delays, but we haven't had any significant delays with assessing those notifications. So I think that process is just getting easier over time as we go.
Thank you. I might have a few more questions a little bit later, but does any committee member have some questions?
Chair, it's Tony Zappia. I'll ask a couple if it's possible, thank you.
Thank you. Please go on.
Firstly, with respect to recent years, has ASIC raised any corruption issues in terms of A, investigating them, and B, successfully prosecuting any of them in the courts?
Thanks for the question, Mr. Zappia. So just to clarify, are you asking in relation to us as a regulator, or are you asking in relation to, per the ACLEI's jurisdiction, activities by our own staff?
I'm sorry, I'm having difficulty hearing you, but my question relates to before ASIC came under ACLEI's jurisdiction, had there been any prosecutions for corruption, or had there been any investigations for corruption?
Yes, I understand. So you're saying about, yes. I think the answer is I don't think we would have found any difficulty, and I think the way I would answer is to say I think what's been increased, if you like, by way of assistance since coming under the ACLEI jurisdiction is, if you like, that better understanding and guidance from the Commissioner and, you know, her organisation as to a framework for investigating those matters, or if they need prosecute those matters. ASIC has had very, very few, and I would have to take on notice the number of investigations, you know, and any prosecutions regarding that prior to that time. Generally speaking, any activities we would have taken would have involved most likely us referring the matters to the Australian Federal Police. You know, in relation to any, you know, investigations or corruption, we would have done a certain amount of investigation ourselves and then handed that to the Australian Federal Police and then put those matters in their hands. So whether or not, you know, there's been, if you like, any difficulties in the past, you know, I wouldn't have thought so, other than probably what's now become, if you like, easier is, you know, a better discussion and a better discussion group with other peer agencies through the support of the ACLEI to better understand what those issues are, how to put the right frameworks in place and the right investigative methods in place. Mr. Gurdon?
So we...
Yeah, go on,
Mr. Zappia. No, I was just going to concur with Mr. Down that I'm not aware of instances in the last 12 to 18 months of any corruption issues being referred, but we'd have to take on notice in terms of what might be any specific instances.
Okay, so with the Executive Integrity Committee, can I ask how many members are on that and what sort of investigative qualifications they have?
I'll take that particular question, Mr. Zappia. So the Integrity Committee, I chair the Integrity Committee, and the Integrity Committee is made up of a number of our executive directors and senior executive leaders, so from sort of core functions across ASIC. The Integrity Committee's role is really to oversight integrity-related matters across the organisation. So our Speak Up program, for example, in terms of a confidential referral line, ACLEI investigations that are currently underway or notifications that have been made. And so the investigative qualifications of the individuals of the committee I couldn't speak to, and I'd have to take that one on notice in particular. But the role of the Integrity Committee is not really to investigate the matters. There is teams who are responsible for undertaking those, and those teams all have a reporting line up to the Integrity Committee, of which then we have some oversight of those investigations that are currently underway. The Integrity Committee will take a role in advising those teams where matters might come up that could be sensitive or complex, but it's primarily an advisory and oversight body.
Mr. Zapier, just if I could return to the answer I gave you, I've been able to receive some better information. And in relation to recent memory, there have been 2 matters in recent times that would cover the type of subject matter you've referred to. One was a matter that was jointly investigated with the Australian Federal Police in relation to unauthorised access, and it was the AFP that laid charges in that respect. There's been another matter in recent memory that relates to a credit card fraud matter, and we ourselves investigated that matter and handed the matter via a brief to the Commonwealth Director of Public Prosecutions to prosecute.
Okay, and just lastly then, and this might be a hypothetical type of example that you might provide the committee, but what sort of things would you need to be on the lookout for with respect to corruption? I mean, in some agencies, it's pretty black and white what the nature of the corruption might be, but with respect to your organisation, what sort of things might likely lead to a corruption investigation or prosecution?
Well, obviously, the types of matters that I've just referred to, such as on unauthorised access to information, seeking to gain access to information, at the behest of a third party. Similarly, excuse me, as I said, such as expenditure fraud, so on. And obviously also trying to then pervert the course of investigations, induce, etc. So there's a range of those types of matters that we would look at. I'm sure Mr. Gurdon has a longer list that he would add.
Yeah, I think Sorry, Mr. Zapier.
No, I was going to say, perhaps, and you could take this on notice, is it possible to advise the committee whether, say, in the last 3 years, any staff member has been sacked as a result of their conduct, and in particular their conduct relating to a corruption type of investigation?
Yeah, if you like, Mr. Zapier, happy to take that on notice, and probably take on notice the types of hypothetical scenarios that, a list of the types of matters that would give rise to corruption concerns that we might think might be likely in our organisation. More than happy to take that on notice as well.
Thank you very much. Thank you, Chair.
Does any other committee member have some questions?
All good. Thank you, Chair.
I just have a few. In what ways has participating in ACLE's community of practice for corruption prevention benefited your agency?
I might let Mr. Gurdon answer that question, given he's more heavily involved than I am.
I think one of the main benefits for us has been the ability to connect with other agencies. So establishing relationships with the likes of ATO, their integrity team, an opportunity to see how those agencies are doing their own corruption prevention work. So I think that's been a significant positive. We've also just taken the opportunity to learn about how we might be able to do our own integrity framework, is what we call it, our integrity risk framework, in terms of how we might improve that. So we're doing pressure testing of some key risk areas over the next 12 months, and we'll be both involving ACLI's team and also the Commonwealth Fraud Prevention Centre in that work as well. So it's an opportunity just to leverage their experience. So I think that's the primary benefit, and then the connection to key groups and other agencies around how they're undertaking their work.
We have an interest in there's been some agencies where there's been identified risk of corruption around their contractors. Can you just give us some insights to the use of contractors, both professional and non-professional, and I use the word professional as in traditional sense, and whether that presents any on your risk register? And if so, would they be under ACLE or not, depending on what their roles are?
Thanks, Chair. The area of contractors is an area of focus for us. I might hand it to Mr. Gurdon just to give an overview of our thoughts and our approach there.
We predominantly from a risk perspective, we have, we're focused on probity initially. So dealing with the potential for conflicts of interest up front with the engagement of contractors. Our principal source of sort of professional contractors are in relation to engaging legal services. So we do have this sort of significant area around that side of things. We also, our IT function is, and they're those two areas that predominantly represent the largest spend for us as an organisation. And we will focus on those engagements. We try to leverage existing agreed services that we've already previously engaged. So not engaging contractors in a one-on-one scenario, using sort of what has been signed off as a panel is one of the areas that helps us mitigate the risk, and also then running that probity and general risk assessment for each new contractor that's engaged. And then once they're actually onboarded, is running them through our baseline vetting service. So effectively, we're authorised by AGSFA to undertake baseline vetting. So we apply that process to new contractors. We also then, once they're onboarded, they are treated, those professional services in particular, treated like we are the rest of our staff. And we apply the same controls to them as we do for all of our staff members.
How many, you may need to take some notice of your contracting pool are under ACLE? I know it would shift, so I'm not asking for precise numbers, but I suppose that the lawyers are giving advice on proceedings, so I suppose they may well come in, but they have their own compliance function. IT is more problematic one, and we've had similar evidence from other agencies. Do you have any reflections on that? You can also take it on notice if you choose.
I think we might take it on notice just to ensure we give a more complete answer, Chair. But I would roughly say that it probably follows our staff number. Generally speaking, would be the point that I would make. But I'd have to look at whether or not the contracts we have, if you like, are equally as distributed as our staff focus in this area of law enforcement. But I think we could take that on notice. As you say, IT is a little bit more difficult, but obviously we have a singular workflow for our regulatory activities and operations. So effectively, anybody working, if you like, on IT would have, depending on their level of access, would have some ability to access certain enforcement records as well. So it's probably broader than I would initially think, Mr. Gurdon.
Yeah, one of the access to systems, IT systems as such, is a factor there to take into consideration. We would have to take on notice to give you a bit more specific answer to that, Chair.
No, I appreciate that. The question also comes from the viewpoint that around the law enforcement test. Obviously, you have to go a bit more of a journey with ACLE, and you may or may not have matters that fall on that fault line. But when you're giving some consideration, one of the things that's come up is that in some agencies, that test comes quite problematic with people like IT workers. They may or may not be within the law enforcement test, but considerably within a corruption risk framework. I'll leave that. That's for your benefit in reflection. So that's where we're coming from.
No. I fully appreciate the point, Chair, and completely agree. So if you like, we'll take that on notice, and probably as part of that answer, we'd probably also indicate the sort of areas where we believe right across the organisation they're covered by this jurisdiction, or if you like, caught by this jurisdiction. So, we'll give you that answer, and I think you'll find that, we've given some thought to the fact that there's a large number of our IT operations that are covered.
Yes, because one of the key focuses of this inquiry is whether a jurisdiction should be expanded and for what agency. So if there's any other further reflections, please don't hesitate to add them. Does any other committee member have any further questions?
Thank you, Chair. No questions.
No, I'm good, thanks to Andrew.
Well, thank you, gentlemen. I'll release you and we'll look forward to receiving your questions, your answers to your questions on notice. Thank you.
Thank you, Chair.
Thank you, Chair.
Secretary. Sean?
Yeah, Chair, we're here.
Yeah, so given that we're going to have morning tea, I propose, unless there's a better course of action available to me, to suspend until 11 o'clock your time.
I think that's the best option, Chair.
So we've got
The ACCC at 11 o'clock.
ACCC, and they can only come on at 11 o'clock. Is that correct?
They are available a little bit early, but APRA, which is appearing immediately after, can't appear any earlier. So moving the program forward probably doesn't help a whole lot.
Okay. Having this discussion on Hansard so that those watching can know what we're doing. So any committee member has any...
Yeah. At about 11:30, I will have to leave the hearings for an hour or so. So I won't be able to participate in the commissioners, the Ackley commissioners hearing at I think it's about 12:10 or something.
Yeah. Okay, thanks, Mr. Zapier.
Chair, can I just have the committee pause for a moment while I ensure the broadcasting is off?
Okay, thank you. Representatives from the Australian Competition and Consumer Commission, Mr. Scott Gregson, Chief Operating Officer, Mr. Bruce Cooper, General Manager. Thank you for speaking with the committee today. The committee has a copy of your submission. For the Hansard record, can you please state your full name and the capacity in which you appear for this hearing?
Thank you, Chair. Scott Gregson is my name. I'm the Chief Executive Officer of the ACCC. That's a slight title change since we would have submitted the list. And with me is Bruce Cooper.
I'm Deputy General Counsel for Corporate Law.
Thank you. I now invite you to make an opening statement if you choose before we proceed to questions.
Thank you, Chair. We can do that very quickly. Thank you for the opportunity to attend before the committee. The ACCC has been subject to the jurisdiction of the ACLEI since January of 2021. In that time, we've built strong connections, sharing information. We haven't had much exposure on matter specifics in that time, but we are seeing benefits regardless of that. The connections, the jurisdiction has been a catalyst for us to focus on issues and where appropriate make adjustments. We see great benefits in the jurisdiction having extended for that period. Otherwise, happy to take questions, Chair.
Thank you. We are interested in the agency's interactions with Ackley in the lead up and after the expansion of its jurisdiction, and any lessons that can be learnt from the Ackley's jurisdictional expansion from your perspective.
Thank you, Chair. As mentioned, we worked closely with Ackley from early in that period, in fact, preceding the jurisdiction actually commencing. That's involved regular meetings at senior and operational levels, having a good communication with Ackley to explain how the ACCC works, where the exposure points might be, and in reverse, having Ackley present to the ACCC about the jurisdiction, about the issues that they would be looking for and the type of working relationship we might have. In addition to those communications, the ACCC has provided, I guess, a large amount of information to Ackley about our various processes, about how we work in an enforcement field, And at a senior level, we're having quarterly meetings between the Commissioner and the ACCC Chair to, again, establish those connections and ensure there's transparency. In terms of lessons that we've identified, I guess, through the last 12 to 15 months of connection, I guess an appreciation that despite some of the mitigating features that the ACCC has in the way we operate, there are areas that we can focus on more, and I'm happy to talk about those. We have...
Please, yes.
Well, okay, I'll pause there, Chair, and go to some of the areas in which we think there's further areas we can focus on. First of all, we see an increased amount of procurement at the ACCC and the AER. That arises from new roles and functions that the ACCC takes on. And so we're considering ways in which we build further central oversight in relation to procurement. We already have pretty good systems in place, but recognise that there's room for improvement there. We're seeing a number of ACCC policies and procedures that we have in place that would touch on the issues, the subject of ACLI, but perhaps room for greater coordination and oversight of those policies. And so we've established a small team within Mr Cooper's area who are undertaking a further stocktake of policies and ensuring that we have good compliance procedures in place. Similar to our experience with increased procurement, the ACCC, I expect like other regulators, is also seeing an increase in the number of contractors that we have working in the agency. Again, this is often a result of outsourced services such as IT. It can also be necessary to bring in particular skill sets for particular purposes. For example, we're quite invested at the moment in increasing our IT capacity, both in the mainstream of the business, but also in specific functions such as the consumer data right. We're looking at, I guess, the further types of exposures that contractors and how we engage with them might bring to the issues, the subject of the ACLI. Finally, I think the ACCC and the AER are heavily focused on information and the availability of information to our people to do their job. We've often focused on making sure that people have access to that information. The other side of that coin is, of course, thinking about principles such as need to know. And I think exposure to the ACLI, some of the issues that do emerge in terms of use of information has helped us focus and think about adjustments we might need in that area.
What portion of your workforce comes under ACLI's jurisdiction?
Thank you, Chair. It would depend obviously on the activity that they're engaging on the day. So some of our officers might be involved in policy at one moment, but then moving towards enforcement in the next. I'd say it sits somewhere around 1/3 of our workforce are involved in investigations, litigation, the type of activity that might give rise to ACLI jurisdiction, though at any one time, half of our employees might be involved in that work.
Does the law enforcement test present you with any practical problems?
Well, it does take some consideration. We've had lengthy discussions with ACLI to try and get the right line there. I think there continues to be, if not ambiguity, then role for clarity about that delineation. For the ACCC in practice, though, we've adopted a very transparent approach with the ACLI. We see benefits regardless. If we see any conduct that would raise concerns for the ACLI in an enforcement context, we would, as a matter of course, raise it with them, even if informally. So from a practical sense, it hasn't caused an issue for us to date, but working out those definitions is not straightforward.
Given the nature of your operations and staff are coming into law enforcement and out of law enforcement, would it be better for your organisation that test or that hurdle test doesn't exist for your organisation? We've had some evidence for it and some evidence where it hasn't affected, but it's been largely driven to date in the evidence we've received by the nature of the organisation and what it's seeking to regulate.
Chair, I'm not sure we've got a formal ACCC position on that. As I said, practically, we've adopted a practice of heightened degrees of transparency with the ACLI. We share with them instances of conduct that we're looking at, regardless of that jurisdiction. The benefits of either extending the scope or removing any restrictions on jurisdiction would be the support we get from the ACLI should a matter arise in terms of their investigative capacity and the support they're able to give in investigations. I think you'd want to look carefully at whether there's particular conduct or areas of activity that are either lower risk or not the type of activity that is intended to be caught. Apologies, that's not a firm position on the issue. We're more, I guess, content at this stage with the interactions we've had.
Yeah, I asked the question. I appreciate it. It's early days in your relationship with ACLI. In your contracting, the use of contractors, do they currently come under ACLI by virtue of what they're doing for you?
Yes, they're most likely to. Again, there are definitional issues around the persons that might be subject to the jurisdiction. We take the view that the jurisdiction catches our commissioners and board members, it catches our employees, it captures contractors or consultants in most instances, and certainly catches those officers that might be on secondment from other agencies or bodies. But there is no doubt some definitional issues around there, and it's a case-by-case basis on both the secondments and the contractors.
Can you just give us a flavour of when you say contractors, the type of task that you're contracting out?
So there's a variety of contractors, Chair. If I start with those contractors who have access to our system but are performing services through a company, so for example, our IT services, our service desk provision of equipment is through a particular service provider, and they have a large number of their employees who have access to our system. We have a number of persons that we contract directly to provide particular skill sets. So at present, as we're building our IT capacity more generally and with this consumer data right, we're having either contract arrangements directly with individuals or through a labour hire provider to bring those skill sets into the ACCC, and that's a contract as opposed to an employment relationship. We also then have contracts for consultancies, those that provide us particular skill sets, whether that be economic, whether it be industry knowledge, and we have contractual arrangements with those people.
Mr Zapier, do you have any questions?
Thanks, Chair, and you kind of asked some of the questions I had in mind, but just on the issue of risks that the ACCC might face, and the issue of procurement has been mentioned. I'm just trying to get clear in my head, from a public point of view, what kind of risks does the ACCC face internally that would be of concern to the public?
Can I just check in terms of that question, are you talking specifically in relation to procurement or more generally?
No, more general. I mean, procurement I can understand is a legitimate risk, and you've mentioned that. But what other sorts of things, as a taxpayer, would I be concerned about that might be happening within the ACCC that should not be happening?
Yeah, thank you. That helps with that clarification. One of the core roles and functions of the ACCC is to investigate, progress investigations and potentially take litigation or other forms of enforcement remedies in relation to competition, consumer protection, product safety, and some of our regulatory roles that involve enforcement elements. Within that frame, it is always possible for concerns to arise about whether decision-making has been biased or influenced at all improperly. The ACCC has a number of mitigating structures and arrangements. Our decisions to direct investigations or commence proceedings, for example, are undertaken by our Board of Commissioners in a group setting. so the capacity for individual influence is lower. Likewise, we have fairly low levels of delegation, that is, we don't delegate much beneath our statutory authorities. For example, the capacity to issue our compulsory notices sits with our chair. We don't delegate that down to staff level. Other factors such as having both a board of commissioners and an executive provides checks and balances. So we think the risks may be lower for the Competition and Consumer Commission than perhaps some other law enforcement agencies. But nevertheless, those risks of bias or influence in our investigative and litigation profile remain.
So if I could ask you with respect to that, and I appreciate that answer and it clarifies in my mind what the risks might be. Have there been occasions in the past where those risks have indeed surfaced and investigations were carried out and any officers of the ACCC have been either dismissed or prosecuted because of that?
It's not uncommon in matters that we investigate that concerns are raised by those who are the subject of an investigation or litigation, and in those moments concerns can sometimes be raised about bias, influence or even reference to corruption. It's very rare in my experience for those to have more information behind them for us to pursue. It's often a claim made without corroborating information to progress. And I should say we don't have many of those in the time that we've been subject to jurisdiction of the ACLI. In my time at the ACCC, spanning back 25 plus years, there may be one or two instances that I can recall where there is further information that has allowed us to investigate. And in those moments, again, I haven't been witness to any instance where those concerns have been proven up.
So given that answer, do you believe it was necessary for ACLI to have oversight over the ACCC? In other words, do you believe it's going to bring or add any value to integrity within the ACCC? And do you believe that even having the ACCC under its jurisdiction was in fact warranted?
Whether you would elevate it to the status of necessary, I'm not sure, but certainly in terms of justification and benefit, I think the ACCC would take the view that there has been justification and benefit. No agency or organisation is free of the risks, despite any mitigation in structure or culture. And indeed, as I mentioned before, having that further focus and relationship with ACLI, I think has helped the ACCC identify those areas of higher risk and make adjustments. Again, not sure I'd elevate that to a status of necessary, but certainly in my view, beneficial.
Okay. Thank you for that. Thank you, Chair. That's all I have.
Does any other committee member have any questions?
All good, Chair. Thank you.
I have a few more. Can we just, you may have mentioned this in your evidence, but since coming under ACLI's jurisdiction, how many referrals have you made to ACLI?
We've made, Chair, no formal referrals. On a handful of matters, we've had preliminary discussions either to traverse issues of jurisdiction or understand the path by which we might explore preliminary inquiries.
Has participating in the community of practice for corruption prevention provided benefits to your agency?
Yes, it has. We've done that at a operational level. So those people who are involved in investigations, coordination and strategic support for investigations, and indeed our legal units. The feedback I have from those and get the benefit of the notes from those discussions is that it focuses the mind, identifies those areas of risks and capacity for us to look at any gaps that might be present anywhere within our system So we're finding that community of practice very beneficial.
If it doesn't go to Ackley and you're having to look after it yourself, what is the process there? Do you have specific investigators that you rely on, or do you give it straight to the Federal Police? But I do appreciate there's often a gap between what might be criminal and what might be a breach of employment practices.
Yeah, so absent the ACLI jurisdiction, we have a number of avenues to consider issues raised. You've mentioned there employment terms and conditions, which include the APS Code of Conduct, which is quite broad and allows us to look at a number of matters. In terms of who within the ACCC would be employed to do that, it would often be a combination of our HR team within our People and Culture branch and Mr Cooper's team in the Corporate Law Unit, which includes our Fraud Integrity Officer who assists with those matters. Should matters prove up and require further consideration from a more formal perspective, the avenues we'd pursue would either be, I understand, the Commonwealth Ombudsman or referral to relevant police, whether it be state or federal jurisdiction. Chair, I might just check with Mr Cooper, who has more exposure, if he has anything to add to that.
Yeah, I mean, the only thing I would add is if it was necessary to undertake a more formal investigation, we could get external expertise in to assist that, provide a report, on which perhaps code of conduct could be based.
You're anticipating my next question. Some agencies carry, because of the nature of their risk, carry qualified investigators. I'm not asking this, suggesting that you should, but do you carry kind of interest any others that have a specialist skill in conducting investigations, or is it always a question of putting it out to an independent third party?
So obviously we've got the skills of investigations embedded within the agency. It's a significant part of our business, though I do appreciate the type of investigations here are at times specialised, and there is that risk of bias or investigating your own type queries. The teams within Mr Cooper's area are trained lawyers who are well practised, I think, in undertaking those preliminary steps. We will always, I think, then benefit if a matter gets beyond a preliminary stage to have the assistance of an external, if not for the skill set, then definitely for that perception of independence, which is important to decision making. And we have a number of firms that we've used from time to time in code of conduct issues or otherwise, and are able to use panel arrangements to employ those firms.
Given now that you're under the jurisdiction of Ackley, have you identified any deficiencies in authority or power to deal with corruption issues, or are you satisfied at the moment that having Ackley available to you is sufficient given your current experience?
Yeah,
I haven't expressed that quite correctly. I'm really looking forward. Have you identified a potential legislative gap that's causing you difficulty, or a jurisdictional gap that's causing you difficulty and frustration in relation to corruption?
No, I don't think we have, Chair. I think those definitional issues that we mentioned before, whether it be what constitutes enforcement activity or that the person subject to jurisdiction, is an area that's worth looking at and continuing to refine. But I think we're comfortable that Ackley has all the experience and capability to look at matters that we may raise with them. And should there be a jurisdictional issue, there's other avenues for the ACCC to refer, such as relevant police forces. The ACCC's capacity to investigate matters itself may be limited in terms of compulsory powers in relation to activity of its own people, but to date we really haven't found that a barrier to us undertaking the preliminary steps before we might refer a matter.
Thank you. I have no further questions. Does any other committee member have any questions?
No, I'm good, thank you, Chair.
Thanks, Mr. Zapier. In the absence of any other committee member indicating, thank you for your evidence this morning. I appreciate that you may take some of those questions on notice, which you've indicated, but you're relieved.
Thank you, Chair. Thank you, committee.
Thank you.
I believe that we've got APRA coming next. Do you want a short suspension, Sean?
Yeah, Chair, if you could, and we'll see if we can get APRA any earlier. We're not sure we can, but we'll try, and then I'll message the rest of the committee to let you know a minute or so before we're ready to go. But otherwise,
so we're suspending to 11:40 your time.
11:40, and the Secretariat will let you know if we're able to commence before then.
Thank you. We're suspended. It's from the Australian Prudential Regulation Authority via video conference. Ms. Roberts, Executive Director, Policy and Advice Division. Mr. Rode, Director, Enterprise Strategy and Chief Risk Officer. Mr. Scott, General Counsel. Thank you for speaking with the committee today. The committee has a copy of your submission. For the Hansard record, can you please state your full name and the capacity in which you appear for this hearing?
Thank you, Chair. Renee Roberts, Executive Director, Policy and Advice, APRA.
I think you're on mute.
Apologies. My name is Peter Rode, Director of Strategy and Chief Risk Officer of APRA.
And Warren Scott, the General Counsel of APRA.
Thank you. I now invite you to make an opening statement, should you choose, before we proceed to questions.
Thank you, Chair. We do have a brief opening statement. Thank you for the opportunity to appear today. I'm joined by my colleagues, Peter Rode and Warren Scott. Warren is our General Counsel and Peter Rode, our Chief Risk Officer. APRA has made a submission to the inquiry, which we hope is helpful in providing some context. I'll briefly touch on a few key points in these brief opening remarks today, and we are then happy to take questions. As the committee will be aware, APRA came under ACLE's jurisdiction on the 1st of January 2021 with respect to corrupt conduct that relates to the performance of APRA's law enforcement function. Since this time, APRA has been engaging closely with ACLE with various opportunity, including regular liaison meetings to ensure a smooth induction to ACLE's jurisdiction, and we are working very well together. APRA continues to reinforce with our employees the various obligations we have regarding corruption, conflicts management, information security, and the like, and reminds staff of the processes in place to report potential corruption within APRA. As outlined in our submission, APRA takes corruption very seriously and acknowledges that a key part in addressing corruption is taking all steps to prevent such conduct from occurring. APRA has benefited and gained useful insights from the work of ACLE, particularly from ACLE's corruption prevention team. In relation to corruption vulnerabilities, these are managed across all of our business functions. Our internal frameworks and policies for managing enterprise risk extend beyond corruption prevention and, as outlined in our submission, cover a wide range of activities that are closely linked with corruption prevention. These frameworks and policies are in place and are in addition to the requirements set out in the Commonwealth procurement rules. APRA welcomes the extension of ACLE's jurisdiction to the additional regulators, including ourselves. Thank you very much. Happy to take questions.
Thank you for your opening statement. Could you describe for us your agency's interactions with ACLE in the lead up to and after the expansion of its jurisdiction, and in particular what lessons can be learnt from ACLE's jurisdictional expansion?
Thank you, Chair. Well, we have had frequent, as I've heard from other agencies as well, we've had frequent interaction with ACLE leading up to the expansion of their jurisdiction, and then ongoing in terms of regular quarterly catch-ups, and then sort of more less formal interaction, which Warren can talk about, as can Peter. But Warren, did you want to just go into some of the engagement that we've had with ACLI since the expansion of their jurisdiction?
Well, actually, even before the expansion, the APRA chair met with the Integrity Commissioner to go over what this may mean to APRA. We have met with our liaison person at ACLI, Pete Ratcliffe, who's been extremely helpful in what we should be doing as we become more acquainted with what the role and the objectives of ACLI have. And we've actually had one instance where we weren't exactly sure how we should deal with a particular situation. And ACLI was incredibly helpful in advising us as to what we probably should do to handle it. And we did make a formal referral to ACLI. That issue at the end, ACLI decided to take no further action. But the process of learning how ACLI operates was most informative for us. I don't have anything more I would want to add.
No, that's fine. It's always a little delay in Zoom, so just bear with us. Since ACLI's come under ACLI's jurisdiction, have you had to make any changes from a procedural perspective or practices and procedures?
So we've been working on our risk framework just concurrently along with the expansion of ACLI's jurisdiction, and we've been doing lots of work to improve our risk maturity right across APRA. And I'll let Peter have a talk to what we've been doing, particularly in regard to improving how we deal with conflicts of interest, which has had a significant focus for APRA over the last 12 to 18 months.
Yeah, thank you, Renee. I'm happy to add. So from an APRA perspective, really for us, it's about guarding the information that we have and making sure that it's managed appropriately. So we've continued to improve the way that we do security clearances. We have done some further evolutions of our conflicts of interest framework. Finally, we have also taken the opportunity to make sure that we have appropriate refresher training for our people throughout the life cycle. And ACLI's expansion of their scope came at the same time as we followed the general probity discussions on the back of Vivian Thom's report into ASIC. And we have done a number of probity reviews across APRA to make sure that we cover everything from members to executives to employees and to contractors. So I think it has really heightened our attention and focused our efforts in those areas of improvement.
Could you give the committee some understanding of, as you've alluded to, your risk profile in relation to corruption? So there'd be probably information like other agencies, access, possible undue influence, just from a very broad level, where the focus of APRA is in relation to its risks.
Yeah. So we have quite a comprehensive risk controls framework as it relates to fraud that covers bribery and corruption, procurement, people information sharing, and so forth. And in terms of our risk profile, I think it's important to understand why, while we are very alert to how APRA information, in particular information about the entities we supervise, could be used, I'm pleased to say that otherwise our fraud profile specifically is on the low side. The only fraud that we have identified over the past few years relate to either external credit card fraud attempts or internal credit card charges that need to be refunded. But we are talking about a couple of $1,000s. So in terms of realized fraud, it's very much on the low side. But that doesn't mean that we are not very aware and alert to what could be realized risks with respect to corruption, and that's why we have put a lot of effort into, in particular, our security clearances and our conflicts of interest frameworks and how we enforce that.
What proportion of your workforce is included in ACLE's jurisdiction? Because one of the things we're interested in is the extent to which agencies come in, and then we'll sort of move to any challenges regarding the law enforcement test. We'd like to take that question.
Yeah, I'll take that question. So basically all staff are covered by, all staff are covered by all of our policies and procedures. So in terms of our training and our security clearances, our pre-employment screening, post-employment screening. The interpretation of our staff that are covered by ACLE's jurisdiction really depends on what they're doing at the time. So while in some respects it's pretty obvious in terms of law enforcement and that particular activity, there are potentially times when in the course of our work that we do in supervision, in resolution, licensing, that other staff would be also covered in ACLE's jurisdiction. I mean, Warren can talk a little bit more about how we interpret that, but for us it would be on a case-by-case basis depending on what activity they're engaged in at the time. Warren, did you want to add to that?
Thanks, Renee. I think one thing that is different possibly about APRA and other agencies that are now covered by ACLE is that under the APRA Act, all consultants, contractors, secondees are all covered as staff. So any actions that they take or fail to take would be subject to ACLE's jurisdiction. So that is
my next question.
Broad. Sorry, sir?
That was going to be my next question about the contractors, but thank you for that.
Yeah, all of them are covered.
Mr. Zappia, do you have any questions?
Thank you, Chair. And you touched on the question I was going to ask, but if I could just take it a little bit further, and that is relating to the potential corruption risks. I guess my question is along these lines. Things like credit card risk would apply to just about any organisation, both public and private. What unique risks is APRA likely to face that ACLE could be of assistance with? So what I'm trying to ascertain is what additional value does ACLE bring to the oversight of APRA, and what risks are unique to APRA that would not apply to other organisations?
Thank you for the question. The way I think about it, and particularly the frameworks we have in place, is really probably around the conflicts of interest and the use of information. So we're privileged to receive quite sensitive information in regard to entities that are in the financial services industry, and it is incredibly important that information stays within APRA and is not shared with anyone in respect to either prejudicing some of our enforcement action that we might want to take, the way we're interpreting some of the information that we're gathering about entities, where entities are with their own risk frameworks, and so that is for us probably a source of risk. There are relationships that APRA people have with people in the financial services industry, and people in the financial services industry are always very, very interested in how APRA is thinking about things. So, you know, being able to keep that information tight, so the declaration of those relationships, those conflicts of interest that people may have. So, look, I do think that those risks are quite unique, and therefore working with ACLI in the broader sense of if something, you know, if we were to come across some activity in APRA that we weren't sure about, as Warren said, you know, being able to reach out to ACLI and consider whether or not there is something that needs to be reported, I think is very helpful.
So based on that answer, and I believe earlier on it was said that in recent years or over the years there's been very little evidence of that type of activity. If that is the case, then is it because we didn't have ACLI oversight in the past that there has been no other prosecutions, or is it because the real risk that you've just alluded to, or the real risks that you've just alluded to, have not proven in past years to be evident?
So, Warren, did you want to take that one, given that I'm haven't been around that long and probably not privy to that sort of information either?
Thanks, Renee. Actually, I've been at APRA for close on to 13 years. And during that time, we have not had an example of misuse of information that is considered protected information or protected documents. There have been times when questions have been asked as to why did people access information, and we have to spend more time, I think, at looking at what are the protections that we have so that only people who need to know are actually accessing particularly market-sensitive information. So the track record to date has been quite good, but you can't stop looking at your policies and procedures just because something hasn't gone wrong in the past. There is always the potential of something going wrong. We have not seen anyone accessing information or leaking information from APRA, but it is something that you must be continually vigilant about.
Okay.
I hope that answers your question.
No, it is. That gives me the answers that I'm looking for. So my last question is this. Did APRA request the government to have ACLI provide oversight over APRA, or was it done without your consultation?
Renee, do you want to take that, or do you want me to answer it?
Warren, I actually don't know the answer to that question, so you can take that question.
So APRA did not request the government to have APRA subject to ACLI's jurisdiction. On the other hand, we certainly did not oppose our inclusion when the additional 4 agencies were added to the original 5 that were subject to ACLI jurisdiction. There is an overlap in that the 4 new agencies have to go through a 3-point test as to whether or not an issue is covered by ACLI, which the original 5 only have a 2-step process. That is something that hopefully will be able to be changed if legislation is adopted regarding the Integrity Commission.
Yep, no, I appreciate that. Thank you very much for that. Chair, thank you. That's all I have.
Does any other committee member have any questions?
No, thanks, Chair.
Was that yes or no? Sorry.
Not from me, thanks, Chair.
Okay, I'll take those as no, but we've got a little bit of time. I'm interested in your reflections on participating in the community of practice for corruption prevention whether that's benefited your agency?
Yes, thank you, Chair. It has benefited our agency. We are enjoying, I think, collaborating with other agencies that are in this space as well, and I know that both Peter and Warren, through the work that we've been doing together with ACLEI, it is broadening our thinking in regard to corruption prevention.
If ACLEI if you weren't tied to ACLEI for those matters about law enforcement, how would you approach a corruption or fraud allegation? Would you internally investigate first, and then do you have any specialist staff available, or do you outsource, as some agencies have?
Yes, so we would absolutely investigate and consider investigating, and it would be a mix of internal staff and, depending on the situation, engaging externally as well. Peter, did you want to add to that? Because I know that.
Yeah, no, I agree, Renee, and obviously we have channels. Firstly, we encourage staff to go to their manager, but we also have anonymous channels. They are very evident for people through their induction, their training, and our intranet. And as you can tell, our risk profile is pretty low with respect to these internal fraud cases, but we do have a fraud officer who is trained as an investigator as well, to the government's level 4 certificate. In my time at APRA, 2 years, he has used those skills once, and we concluded that it was not a case of fraud.
Does any other committee member have any questions? Well, thank you for your evidence today, and we'll release you. Thank you.
Thank you.
Thank you, Senator.
Now, I understand ACLEI is, well, actually, I think I can see ACLEI coming to the table. Mr. Scott, you're still online. There's no need for you to remain online. Thank you. Are we ready to go?
Yes, thank you, Chair.
It's a little difficult from where I am to see. My apologies. I now welcome representatives from the Australian Commission for Law Enforcement Integrity. As far as I can see from where I am, so correct me when I'm wrong, we have the Integrity Commissioner, Ms Lind, the Executive Director, Operations Northern, Mr Radcliffe, Executive Director, Operations Southern, and Ms Atkinson, Executive Director, Corporate Services and Governance. Thank you for speaking with the committee today. The committee has a copy of your submission. For the Hansard record, can you please state your full name and capacity in which you appear for this hearing?
Thank you, Chair. Jarla Hinchcliffe, Integrity Commissioner.
Mr Peter Ratcliffe, Executive Director, Operations Southern.
Judith Lind, Executive Director, Operations Northern.
Lucinda Atkinson, Executive Director, Corporate Services and Governance.
Thank you. Do you have an opening statement?
Chair, I don't have an opening statement, no.
No. So therefore we'll proceed to questions. I I'm working on the basis that you've heard much of the evidence.
Yes, Chair, I've been listening all morning.
No, thank you. That makes things a little easier. Would you like to flesh out, from your perspective, your assistance to agencies in determining whether corruption allegations fall within ACLE's jurisdiction? Because we've heard some evidence, admittedly by some agencies this morning, where they haven't had a lot to hand over to you, which is a good thing, but also we've had a mention of a two-step to a three-step. We've also had some evidence in relation to your consulting on certain matters, so your perspective would be enlightening.
Thank you, Chair. I think I'd start with saying that it has been a fairly quick process of bringing these new 4 agencies into our jurisdiction. The fact that they were coming within our jurisdiction was announced in the October federal budget in 2020, and that they would start in our jurisdiction on the 1st of January 2021. As part of that process, we received additional funds and additional ASL in order to deal with the additional 4 agencies within our jurisdiction. At that same time, because of those additional funds, I was able to bring on an additional branch into ACLE, and Miss Lind and Mr Ratcliffe came onto the executive team to settle our executive team as 3 Band 1s and myself. So it was it's been a time of great change for ACLE in bringing in those new agencies, and a time of great growth for ACLE. And I will say that I was quite heartened to hear today the reflections back from agencies that we've brought into our jurisdiction, that they have found the consultation with ACLE to be useful, that they have seen this as being a working relationship where they can call upon us for assistance and to talk through matters, that they have felt supported by ACLE through a very quick turnaround of bringing them into our jurisdiction. And a recognition that yes, there is a difficulty, and there has been some greyness in relation to the 3-step, the 3-limb test of whether a matter is within jurisdiction for those agencies, with the additional law enforcement test that applies to them that does not apply to the other agencies within my jurisdiction, but that they have felt like we have worked that through with them, and though there is still some uncertainty in relation to how that test will apply in every case, that they have felt supported in that process. So you don't often get that kind of feedback, and it was really impressive, I thought, today to hear that feedback, and I'm very grateful for the work of ACLE. I'm very grateful for the work of my staff in enabling this to happen, and the work that they've done to bring those 4 agencies on. And I'm very grateful for the way in which those 4 agencies have approached their work with us. They have been open to working with us. They have been contributors to our community of practice. They have met with us regularly. They have provided opportunities for us to speak to their staff about the work that we do. And it has set the relationship that we have with those four agencies on a really firm footing. And I'm very grateful to them for that. So far, in relation to those 4 agencies, last financial year, so from the 1st of January 2020 till the 30th of June 2021, we had 12 matters referred to us in relation to those 4 agencies. So far this financial year, we've had 21. So the numbers are small. They are... it means that it is an iterative process, that we are learning about that law enforcement test. It means that it seems to me from the matters that have been sent to us from agencies that it is borne out the evidence that they've given to you today, that they are taking a cautious approach. We've had a number of matters that they've referred to us that on assessment by us, they've been out of jurisdiction. So that says to me that they're taking a cautious approach and referring matters to us where they think they could possibly be in jurisdiction to make sure that they're picking up the right matters. I suspect, so we've seen a slight increase in matters that have been referred to us so far this year. I suspect that we will continue to see a slight increase in those matters going forward, and we will continue to work with agencies in relation to the definition of the law enforcement test and how that is applied. The evidence I've given before this committee before has been that that I was of the view that there would be some cases where they were clearly within the test of being a law enforcement function. There would be some cases where they were clearly outside of that test, and there would be a group of cases that would be within the grey area. That has borne out to be true, and we have needed to go and get legal advice on a number of matters. And that legal advice has at times taken more time than we would have wished because of needing to tease out exactly what the person's position was within the agency, what their conduct was that was being alleged, and how that then related to the law enforcement test. And this can be almost like conducting a preliminary investigation to tease all of that information out to determine whether or not a person is within jurisdiction. We're seeing a separate issue that I admit I hadn't considered, about the possibility of a person being within jurisdiction in relation to conduct, and then in the course of our investigation us discovering other conduct, and then needing to reapply the test in relation to that secondary conduct to determine whether or not it was engaged in the course or related to a law enforcement function. I hadn't even considered that possibility, but we currently have a matter where we are working our way through that potential, and the possibility that a person may engage in some conduct and be within our jurisdiction, but in relation to other conduct that we identify in the course of our investigation, they're not within our jurisdiction. We are in a lucky position that we work very closely with other law enforcement agencies and have good relationships with other law enforcement agencies. If it turns out that a matter is not within our jurisdiction, then we would look to handing that over to another law enforcement agency to finalise the investigation.
I'd like to focus on that jurisdiction point, if I may, at this point. It's interesting, some of these agencies have, from a jurisdictional perspective, almost a tidal movement. You might have 10 staff with a particular matter go into law enforcement and then retreat back at the end of a month into doing other work. So your jurisdiction is actually moving depending on what the staff are doing. But that could also, in my mind, also operate in the course of a week. On Monday and Tuesday, you could have a staff member in ACLI's jurisdiction, and then the rest of the week not. And you could have two staff members, so correct me, push back at these from what I'm saying, but from my understanding, you could also conceptually have two staff members sitting next to each other, figuratively, one in ACLI because they happen to be doing law enforcement but virtually the same corrupt activity, and the one sitting next to that person, not in ACLI, but committing equally corrupt behaviour of almost the same nature. Is that, I don't get a sense it's causing a problem now, but is that exercising your mind?
Yes, Chair.
Particularly with reviews of jurisdiction and within the confine, in the nature of this particular interest of this particular inquiry?
Yes, Chair. It is exercising my mind, and I think that the way that you have just explained it is absolutely correct, and it is being borne out in the example that I've just given of us thinking about additional conduct that we've discovered in the course of an investigation, and the potential that conduct may not be covered, similar conduct, but may not be covered because of the different roles and functions that the person is playing within an organisation. And it seems to me that's potentially it's an unwitting outcome of the way that the definitions work. We talk about the law enforcement test as in that kind of terminology, but it's actually important, and I'd encourage the committee to go back and have a look at the definition of law enforcement function within the Leak Act, because it's quite a narrow definition as well. So in the normal course, we'd think about law enforcement, and we think about that in we might think about that in quite a broad spectrum. But the Leak Act has quite a definite definition, and it is narrowly framed in connection to criminal offences and civil penalty provisions. So we also need to be very careful to keep going back to that definition and making sure that it meets the confines of that definition as well. Mr Radcliffe
Yes.
and Ms Lynn, you're dealing with these matters every day. Is there anything further you wanted to add in relation to that?
I think just to table another example in the ATO context and what mischief could be got up to in that context. I mean, the tax office has got a vast number of auditors who are running compliance programs, so looking at whether taxpayers have complied with their tax obligations. If the outcome of that audit work is simply amending a tax assessment and raising some penalties against the taxpayer, then that's not going to satisfy the law enforcement function test at all. And yet you could imagine that that's potentially a high-risk environment for potential corrupt conduct or misconduct in terms of the bribing of tax officers to achieve an advantage for a taxpayer. On the other hand, there is other functions within the tax office that are directly related to an outcome of building a brief of evidence for a criminal offence and or applying some of the civil penalty provisions in the Tax Act, where people associated with those functions would likely be caught in ACLI. So again, it's just an example of a sort of an unlevel playing field in terms of like conduct or misconduct, depending on the nature of the function that the person is performing as to whether it's caught within ACLI's jurisdiction.
It's also, in my mind, we are looking at obviously from a regulatory point of view, but also from an individual's point of view. One, be subject to powers of compulsion to speak, and the individual in another context will have a different set of rights and obligations. Have you turned your mind to that? Just give you a chance to comment on that, because it's not all about from a regulatory perspective, it's also from an unlevel playing field of the individual.
Ms Lynn, did you want to continue that answer?
That's correct. I mean, I think an ACLI investigation will generally proceed from a perspective of whether there's sufficient evidence to lay criminal charges. And you're right, we are then able to access all the telecommunications powers, surveillance devices powers. We can't use our coercive hearings under the Leak Act, though, to gather evidence against that individual and use it against them in the context of building that criminal brief. So the use of our coercive powers in that sort of context, there's checks and balances against that. To that extent, it's kind of a no, and if we are interviewing witnesses or person of interest, that's being done under caution. So that would be exactly the same process if a matter from the tax office had been referred to, say, a State Territory Police Force or the AFP. So there's a consistency of approach there at the front end of investigations. certainly if we get to the stage where we don't believe there is sufficient evidence or we need to use our coercive powers to interview witnesses, then that clearly is not a power that our jurisdictional agencies, by and large, has available to them and can use.
It was just helpful to sort of get that on Hansard from a jurisdictional perspective, so thank you for that. Whilst we're talking about the ATO, we have had some evidence in relation to potentially them using the Inspector General of Taxation and the Taxation Ombudsman. What are your dealings with them in the context of your operations?
So we have, sorry. I was just going to, I'll start.
I also appreciate.
We have met with.
I also appreciate it's been a fairly short time with these agencies. So
that's right.
But if you have formed some views, I'd be interested.
We have met with the Inspector General of Taxation and the Taxation Ombudsman, and I've met with Ms Payne on a couple of occasions to discuss the interaction between our role and her role, and to consider the processes through which, if they saw something come across their desk that didn't fit within their purview, which is around, particularly around maladministration, picking up their ombudsman role, but went more towards corrupt conduct, of how they would refer that to us. And if they could refer that to us, and for them to think about their own secrecy provisions and how that would work. So we've had those conversations at that kind of level. Ms Lynn, anything further you'd like to add?
We've had 2 notifications from them, from my memory, and they're coming across to us under Section 23 of the Leak Act. We also have another current matter where we're just working with them in a dialogue to sort out whether it relates to ACLE's jurisdiction or not. About 3 or 4 months ago, we also had a workshop with their team where they identified some common case studies of the matters that they tend to get, sort of complainant matters that they tend to deal with. And we've used that workshop as a learning process for both organisations to work out what matters might flow via the Inspector General of Taxation.
Thank you. I'll just give an opportunity for any other committee members to jump in if they want to. No? I have a few more questions myself. Have you identified with the referrals over, I think, just over a year, any particular trends or types of behaviour?
So, Chair, I would say that the types of behaviour that we've seen in the notifications so far are similar in respect to what we see in the broader law enforcement jurisdiction that we have. We've seen matters that go to unauthorised access to systems and to information. We've seen matters that have allegations of abuse of office, particularly around decision making. We've seen allegations of bribery, and we've seen allegations that relate to conflicts of interest in decision making. Ms Lind or Mr Ratcliffe, do you have anything further on those sort of trends?
No, I think that's exactly right, and probably goes to some of the points that we made in our earlier appearance at the hearing, Chair, around these types of activities and the types of things that we're seeing are not limited to any particular department or agency, or indeed type of department or agency, but are probably the same things that one would see across the public service as a whole.
From my mind, at the moment, the access to information and conflicts of interest, which it's not surprising that they would be on your list from my perspective, but it does sort of tie into the boundaries of ACLE's jurisdiction, because those two would easily emanate, for example, from an IT department or an IT contractor. So I'm just interested in your reflections. Given those themes, does that then drive your thinking towards needing further jurisdiction over contractors? Particularly for some agencies, it doesn't appear to be a problem, but for other agencies, it is a bit of a fault line. I'm not sure I probably articulated that, but if you need some clarity, I'm happy to have another crack at it.
Chair, I think as I gave evidence at the last at our last hearing, I have thought about this particularly in relation to corruption risk, and you can look at it in terms of unauthorised access and conflicts of interest in relation to corruption risk, particularly in relation to access to IT systems, whether you're an ICT contractor or have access through some other contracting arrangement. But that information that Commonwealth agencies hold is particularly valuable across a number of agencies, particularly agencies within my jurisdiction, but a number of agencies outside of my jurisdiction as well. And it's the access to that information that we see as a common theme across a number of our investigations. The conflicts of interest piece in terms of people's access to decision making, whether it be bringing people on who to benefit family members, whether it be to make other decisions such as procurement. I'm particularly concerned, as I mentioned last time, about from a strictly law enforcement perspective, about the container examination facilities, where contractors are used in that space to do similar pack and unpack roles as conducted by other members of ABF, and the access to information there is particularly sensitive information. So if you use that corruption risk lens, I think there are risks that go out to contractors, that it is useful for there to be a discussion and policy decisions about the extension of ACLI's jurisdiction to cover those. In terms of the broader APS, I've taken the view that while my jurisdiction is narrow in relation to the now 10 agencies that come within my jurisdiction, noting that the Office of Special Investigation came into our jurisdiction in December last year, that there are learnings from ACLI investigations that it is useful for me to share across the Commonwealth. And that's one of the reasons why, for example, I decided to publish our corruption vulnerabilities brief this year and send that to Commonwealth departments so that they can be thinking about their corruption risks, whether or not they're within my jurisdiction.
Does any other committee member have any questions? We have you this afternoon for our annual report, so if a committee member may wish to ask further questions. I don't have any questions. We had a tremendous amount captured at the last. Is there anything you'd like to add in the context of having heard the evidence today, other than what you've mentioned earlier?
I'll just have a look down the table and see if there's anything else from my colleagues here. No, thank you, Chair. We thank you for the opportunity to be able to give evidence both a week ago and today. And we thank you again for your work and the work of the committee in relation to this inquiry.
I appreciate that. So we'll leave it there with yourselves, and we'll look forward to addressing the annual report this afternoon. This concludes today's proceedings in relation to our inquiry. The committee has agreed that any answers to any questions taken on notice today's hearing should be returned by Monday, 7 March 2022. Thank witnesses for their evidence to the committee today. Thanks also to Hansard and Broadcasting. I'll declare the hearing adjourned. Secretary, is there anything else you'd like me to do? of the Parliamentary Joint Committee on the Australian Commission for Law Enforcement Integrity for its examination of the annual report of the Integrity Commissioner 2020-21. I welcome the Integrity Commissioner, Ms Hinchcliffe, along with other ACLEI representatives, Ms Atkinson, Executive Director, Corporate Services and Governance, Ms Lind, Executive Director, Operations Northern, Mr Radcliffe, Executive Director, Operations Southern. Thank you for coming to meet with the committee today. This is a public hearing and a Hansard transcript of proceedings is being made. The committee prefers evidence to be given in public, but under the Senate's resolutions, witnesses have the right to request to be heard in confidence, described as being in camera. It is important that witnesses give the committee notice if they intend to ask to give evidence in camera. I remind committee members that the Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matter of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. Before the committee starts taking evidence, I remind witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and any such action may be treated by the Parliament as a contempt. It is also a contempt to give false and misleading evidence to the committee. For the Hansard record, could you each please state your full name and the capacity in which you appear today?
Jarla
I also
Hinchcliffe.
invite you...
Sorry, Chair. You keep going.
No, you go. And then I'll come back to
Jarla
the
Hinchcliffe,
last.
Integrity Commissioner.
Pete Ratcliffe, Executive Director, Operations Southern.
Judith Lind, Executive Director, Operations Northern.
Lucinda Atkinson, Executive Director, Corporate Services and Governance.
Commissioner, do you have an opening statement?
No, Chair, I don't have an opening statement.
Then we'll proceed to questions. Just bear with me while I just organise my notes. I'd like you just to open the proceedings by talking through what approach was taken to revise ACLEI's performance criteria for 2021 annual report, particularly the measures and targets, and your plans to oversee and manage those measures and targets, ensure the right supports are in place to see that they're being met.
Thank you, Chair. Our KPIs were reviewed and recast in 2020 prior to the 2021 financial year starting, so that we could have them in our corporate plan for the year 2021 and could report on them for the first time in this annual performance statement for the 2020-2021 year. Some of the drivers for doing that piece of work to review our KPIs included the ANAO's performance report in relation to ACLEI, efficiency and effectiveness, in which they made a number of recommendations in relation to how we could measure efficiency and effectiveness going forward. So there are, and you'll see from our performance statement, a number of KPIs that we have included that were KPIs that were recommended or referred to by the ANAO through that process. We also went through a process of looking at the KPIs that were that are used by other agencies that are similar to us, whether they be other oversight agencies like the Commonwealth Ombudsman or other anti-corruption commissions such as the State and Territory Anti-Corruption Commissions, to have a look at the types of KPIs that we could use that could be used for benchmarking purposes into the future, noting that one of the recommendations by the ANAO was that we start to consider the ability for us to be able to benchmark our performance into the future. We also went through a process where we thought very carefully about what is it that we do, and we came up with 4 key functions. We assess notifications and referrals, we conduct our own investigations, we assist agencies with the investigations that they conduct, and we engage in corruption prevention work. There's probably a 5th function that we are starting to do, which is referred to in our Act, and that we'll continue to consider in our KPIs going forward, and that's detection. So the increase in our resourcing has allowed us to stand up a strategic intelligence and data analyst team, and one of the things that they will be able to do in conjunction with a small resource that we have internally in relation to human source work is to do some detection work coming out of looking at some of the themes and some of the corruption hotspots that we see in relation to some of our agencies. This is the first year that we have reported on these new KPIs. There's a lot of them. We have aligned them to the 4 key functions that I've just talked about, and we are using them internally to think around issues particularly to do with our timeliness, to ensure that we do not get ourselves into a position that we've been in previously where we have a backlog of investigations. So using them to make sure that we're not taking on too many investigations, or that we're not finalising our investigations. So you can get to a point in an investigation where you've done all of the work, and that last 10% of finalising it, writing the report, can be difficult to get to. We want to make sure that we are getting to that and we're getting our reports out in a timely manner. That's what what we're using our KPIs internally to be able to measure and consider our business. We need to keep these KPIs under assessment, it seems to me, and under review, because it may be that we have picked some KPIs here that talk to the business that we do, but when we really get down to it, we think actually that piece of information is useful and interesting for us as a business, but is not really telling much of our performance story. And an example of that possibly could be the number of times that we refer information to agencies under Section 146 of our Act, which is when we send material back to agencies because we think that it may go to a disciplinary issue for a person. We're currently counting that in our KPIs because that's a piece of work that we do, and it was important to us to begin to see how often we were doing that. It may be that into the future that will not be an important KPI for us. So we've gone broad. We'll keep them under review. We're particularly focused on the assessment KPIs at the moment, and whether we've got those right. I suspect we haven't got them quite right, but we will continue to work on them. But we hope that this starts to tell a more nuanced explanation of our performance story and what it is that we actually do. I'm also conscious of the fact that under the Leak Act and the regulations, there's a number of statistics that we are required to provide in the annual report, which are currently in Appendix 3. And we are looking at ways to make sure that those statistics, because those requirements came before the requirements for an annual performance statement and the kind of detailed KPI reporting that we're doing, I'm very keen to see that those statistics and our KPIs sit together to tell a really clear story to both this committee, to ourselves, to the members of the public about the work that we're doing. There's probably a little bit more work we can do there, and we'll look to picking that up in this year's annual report.
And I thank you for that answer. I'd like a little bit more information on that potential 5th pillar. Is that designed to enhance your ability to take a referral, or is that you going to, or is that you self-initiating?
So, Chair, under the Leak Act, one of the functions, one of my functions, and I'll just find the provision at section 15, is to, in fact, the first function is to detect corrupt conduct in law enforcement agencies. What has happened in the past, because most of our work comes to us through notifications from the agencies or referrals from third parties, we've relied on that system to consider the investigations that we will take on and the investigations that we'll send back to other agencies to do. There has been some work that's done in that detection space. For example, it may be that in the course of an investigation, we identify other corrupt conduct, which we have detected in effect through our investigation, which we can then, through an Integrity Commissioner own motion in effect, can investigate. We also scan what's happening across our environment, including through newspaper reports, to see whether there are things that are getting picked up in other places that might suggest a corruption issue, and then if we see that, we then ask for further information from agencies to be able to determine whether or not it's something that fits within our jurisdiction. So there is an element of detection that goes on at the moment. We are looking at how we can, with the resourcing that we have, better fulfil that function to detect corrupt conduct. Most of the detection will come from the agencies themselves and from third parties. But to the extent that we are able, through looking at trends that we have through our own capabilities, we want to ensure that we're doing that work. Now, those two areas sit within Mr Ratcliffe's space, so I'll just see whether he has anything further to say on the work happening there.
Thanks, Commissioner. Chair, I would probably add both of these capabilities in terms of the human source work and the strategic intelligence work. They're pretty nascent. So we started recruiting for the strategic intelligence team in July of last year. So we've now got a pretty much a fully staffed team. The only thing I'd add, I think, to what the Commissioner said was that a lot of the work in the strategic intelligence space will not be a case of the agency working on its own. It'll be through close work with our jurisdictional agencies, but also hopefully with our colleagues in state and territory anti-corruption places as well. So we are trying to identify themes and trends which will then enable us to feed back into the jurisdictional agencies, not to cast a wide net and say, you should look at all of these individuals. You know, we're very conscious that there's a fine line between going on a fishing expedition and, looking for things that aren't there, but actually being able to potentially help our agencies to target the work that they're doing in a slightly more specific way.
Thank you. Mr Zappia, do you have a few questions?
Chair, thank you. I do have a couple of questions, and one in particular might be a question that the Commissioner might not want to answer in a public hearing, but perhaps in an in-camera hearing. But I'll go through the matters that I have some concerns with. Has there been any matters referred to ACLI that were not pursued by the relevant government departments or agencies, and in turn, ACLI considered them sufficiently serious to pursue them, whereas the department from where the allegations arose did not consider them serious enough?
Thank you, Mr Zappia. So we have the requirements under the LEAC Act for agency heads to notify us of any corruption issues, and my sense is that that they do refer to us the matters that they're required to. But I think the point that you're getting to is whether there's then been matters that have come to us through members of the public that we've decided to take up. Across this financial year, I'm not sure whether there have been, but I might hand over to Miss Lind, who looks after the assessment function, so that she can give you a sense of what she's seeing, particularly in those numbers that come through from both members of the public, but also in that section 23 space. It includes referrals that we get from other agencies about agencies. So it may be that, for example, the AFP in some of their work uncovers some information about a different agency, and they will send it through to us for us to consider.
Thank you, Commissioner. I mean, to sort of simply answer the first part of your question, there has been, in my last 12 months, the occasional debate or discussion with a particular agency and ourselves, and that discussion's about what is the appropriate course of action to take here. And that mainly relates to matters where we've received the notification from the agency, we've assessed it, there is a corruption issue, but the nature of the matter is such that we've referred it back to that agency to investigate. Depending on which agency we're talking about and the nature of their in-house capability, they might decide to deal with it via a code of conduct matter, so an internal investigation under the APS Code of Conduct. There's probably been a rare instance, only one instance, where we had formed a view that perhaps a criminal criminal pathway may have been appropriate, and we have those discussions on those matters as those differences of approach emerge, but that is certainly the exception rather than the norm. In terms of some of the referrals that we get from members of the public, we've had quite a few notifications of individuals that are disgruntled with the regulatory approaches of a regulator. So I'm thinking particularly here around some referrals to do with, ASIC or APRA. Those are matters where, as part of our triaging and part of our assessment, we gather whatever information we believe is relevant, including information directly from the agencies to whom the corruption allegation is being made, and then we go through our assessment process, and then we make a decision about whether a corruption issue exists and how that should be dealt with. But other than my first example, I can't think of one example where there's been a major dispute between ourselves and the agency to whom the matter relates as to how it should be dealt with.
Okay, well, perhaps just for clarity, if I can give you a hypothetical example. I'm a whistleblower. I approach, and I use the AFP, it could be any agency, but I approach the AFP, provide them the information. They in turn refuse to pursue the matter. I then go to ACLI. ACLI in turn looks at it and says, no, we will pursue this matter. Can you think of examples such as that have occurred?
Well, it depends what's been alleged for AFP. There have been a couple of examples where the AFP has not pursued a matter because they're applying their own internal policies and processes to that matter and have come up with a decision that they're not going to pursue what is being alleged, which is their right to do. And right. By the way, the allegation doesn't necessarily, when lodged with the AFP, come across as a corruption allegation. When that person is then dissatisfied because they haven't got the AFP to do what it is they want to be done, and I can think of a couple of examples where there's been allegations of perverting the course of justice, that the AFP should have as the Commonwealth's law enforcement agency, should investigate but didn't. The next step for those individuals then is to lodge a referral with ACLI, and of course in the context of that referral there is the general allegation of corruption, both in terms of the AFP's decision to not do what they want to do and whatever is the underlying topic that has exercised this individual. But we're applying different tests and different pieces of legislation, so we have to look at, obviously apply the Leak Act to what is being alleged. Whether or not the AFP, how they made their decisions as to whether to investigate the matter is entirely up to the AFP and their policies and procedures and the application of the AFP Act.
Yeah. My question could have applied to any other agency other than the AFP, so and I just say that just to put it in context, I wasn't having a specific question addressed at the AFP, but it could be any other government department.
Yeah.
With respect to the new departments that have now come on stream, from your interaction with them thus far, are you satisfied that they understand and cooperate fully with your own responsibilities?
Mr Zapier, I'll start that and then I'll hand over to Mr Ratcliffe and Ms Lynn. My experience so far with the heads of agencies of all those agencies is that they have been willing and able to come within our jurisdiction. They have wanted to understand how our processes work so that they can make sure that they can comply. And they have put senior people onto the job of coming within our jurisdiction. There's been a number of agencies where they've invited me to go and speak to their senior executives about our role and about the work that we do. And so I've seen a real willingness from agency head down to engage with us and to understand what their requirements are, particularly given that under the Leak Act there's mandatory notification requirements for agency heads, and they have engaged in that process very well. Mr Radcliffe and Ms Lynn work very closely with the agencies at various levels, so I'll hand over to them to see if they have any other views on that.
Okay.
Thank you, Commissioner. Mr Zapier, I have responsibility at the moment for two new agencies, the ACCC and APRA. I can honestly say that since I've been on board, which was shortly after those agencies came into jurisdiction, they have gone out of their way to reach out both at a sort of strategic level to get the background information they need on our agency and the reasons why they would need to interact with us, but also very keen to reach out early when they come across instances within their own agencies that they are not certain whether it's reaching the appropriate threshold to a refer. So we've had a large amount of conversations, both, as I say, at that sort of general level, but also using specific case studies as to whether or not they have, or they're getting close to the threshold at which they need to refer. Again, to echo the Commissioner's point, I've given presentations to as many of their staff as were willing and able to join us, just to give a background on the agency. And we've gone through various things such as the law enforcement test, which you've heard a lot about over the course of a couple of other hearings. We've talked about our corruption prevention work. So in a nutshell, there's definitely been a lot of two-way engagement, and a lot of that has come from those agencies really reaching out and trying to understand the reasons why they may need to interact with us.
Okay, thank you. Perhaps my last question, and this is the one that is a little sensitive, so if you don't wish to answer it or would rather answer it in camera, I fully understand. But given the level of concern with respect to all types of matters that have been reported on in recent months, about foreign interference, do any of the matters that ACLI investigated, or have any of the matters that ACLI has investigated, had in any way links to a foreign power or someone from overseas that was trying to influence our systems? Now, that could simply be hacking our health systems or whatever, but it could be other matters as well.
Mr Zapier, I'm not aware of any investigation that we're currently undertaking that has those types of hallmarks. I'm just looking to my colleagues, and they are both shaking their heads. No, I'm not aware of that.
No, okay. Well, that's. I appreciate the answer, and that's good to hear. Look, I don't think. Perhaps my last question is this: ACLI's now been doing its work for the last 15 years or so. Do you believe it's made a difference to both the culture and the level of crime or criminal activity within the government services broadly, in other words, within the public service sector, because that's where all your work relates to?
I think I can only speak to that, Mr Zapier, for the last 2 years that I've been the Integrity Commissioner. And I am conscious that in that time we have gone from being a tiny agency of about 40 staff to now an agency of nearly 100. And I can see in the work that we have done over the last 2 years the impact, the growing impact that we are having in terms of not just the individual investigations, which are really important, but often those investigations happen covertly and people don't know what has happened in relation to them until either somebody is arrested or a matter goes before court, or maybe they never hear about it because what we found was that the allegations weren't substantiated. Which is why it is so incredibly important that at the same time 2 other things happen, that we must report on our investigations and we must do that in a timely fashion. And you can see from this annual report the work that we have done in the last year to move that backlog of reports that we had and to get those both to the attorney and then to consider them for public consumption. As I said to this committee in a previous hearing, in the last 2 financial years, I've provided 21 reports to the Attorney General, and we are very nearly through the backlog. But it is of utmost importance that we get that out, so that people can see that we are impacting the system and that we are investigating. The other thing that I think is vitally important is our corruption prevention work. And you would have heard from the agencies this morning who were speaking to you in relation to your other inquiry, the way that they have connected to the work that we do through the corruption prevention work that we do, the way that it helps agencies think about corruption risk, learn from each other and implement different mechanisms as corruption controls within their agencies. And that's why I've taken the position of thinking about the learnings that we can share, not just with our agencies, but across the Commonwealth in that corruption prevention space, so that we can be amplifying that important message out across the Commonwealth. So I think that yes, we are having an impact, but I think it's vitally important that we continue, particularly on those 2 pieces of work, making sure that our reports are out in a timely manner, making sure that our investigations are done in a timely manner, our reports are out in a timely manner, and making sure that we're engaging with agencies in relation to the corruption prevention piece as well.
Okay. Thank you, Commissioner, for that. Chair, that's all I had, so thank you.
Thank you. Does any other committee member wish to ask some questions at this stage? I have a few more. Just moving on, just building on what Mr Zapier sort of asked. Various of your new agencies and existing agencies have internal investigation abilities, which they would have used before they come under your jurisdiction and now use if the individual is not within your jurisdiction. Have you had any concerns in the reporting period regarding the progression of any matters under investigation by those agencies? Our questioning has been about, obviously, keeping your workflow within reasonable timeframes. Have you had any causes of concern in relation to the agencies and their handling of matters?
Thank you, Chair. So,
and you can answer that in camera if you need to.
No, I think we can answer that publicly. We are very conscious of the fact that some of our agencies probably have been holding too many investigations because we've referred too many matters across to them in the past. And you can see that in the figures in the annual report that we have some agencies, Home Affairs in particular, that were carrying a significant number of investigations going forward. That's, I think, unsustainable for them, and we need to be conscious of the resourcing available to each agency in relation to conducting their own investigation. That's one of the requirements under the Leak Act in section 27. So we have undertaken a piece of work, and this sits in Mr Ratcliffe's branch, so I'll get him to speak to it in a moment. Similar to the work that was done in Ackley in probably 2019, when there was a review of all the investigations that Ackley was holding, because Ackley was in exactly the same position of holding way too many investigations and not getting through them in a timely manner. And the former Integrity Commissioner reviewed those investigations and determined that a number of them should be discontinued. We are now undergoing a similar process for our agencies to work with them firstly on the investigations that they have to determine whether there are some there that they've actually done as much of the investigative work that they can and they should be discontinued, to consider whether there are investigations that they have that are better placed with Ackley because they've got to a point in the investigation where actually they need some of the powers that we have to enable that investigation to go on. And so that's been a process we've been going through with each of our agencies, and I'll just see if Mr Ratcliffe wants to say anything further on that.
No, again, I would just add that this is in the interest both of the agency in terms of ourselves and in terms of the public. If there are cases that we can work more closely with those agencies on, or that we can get referred back to us because, as the Commissioner said, they have reached the point where that would be of help. The last thing we want to do is to prevent the agencies being able to work on the most serious matters that they have, because we are in effect not holding them up, but because they have a large amount of historical cases which they're not able to get through. So I think it's just a matter of taking a little bit more of a proactive approach, and I would say that the increase in the size of our agency has given us the scope to be able to actually do that. It was a very difficult job for a tiny agency to be able to focus on those once they had gone away. So having a few extra people where we can focus on this sort of thing, I think will be a benefit.
Given the nature of your relationship with these agencies and the collaborative nature, it seems to me you're almost a de facto reviewer of some of their own reports and findings. So I'm just interested whether you give feedback on the quality of their reports, or you see that as part of the ongoing collaboration. Because in essence, you've got a series of very different organisations with different focuses, with different skill sets, and that's all appropriate, ranging from, Home Affairs, which has got to do with a processing plant, a different corruption risk matrix, versus, let's just say at the other end, APRA, which has probably a lower propensity at this stage for corruption risk because of the nature of its business, but doesn't do as much with outsourcing. So, I mean, probably a bit of a broad characterisation. So I can imagine that over time or today you would have received, a varying degree, with some departments very, by virtue of experience, producing quite sophisticated inquiries versus the other end. Do you have any insights for us in relation to that?
So, Chair, I would go further than saying that we have a de facto a role there. Under the Leak Act, it sets out quite a clear feedback loop, which I'm really pleased is there. Agency heads must prepare a report under the Act and provide it to me, and then I may provide comments or recommendations in relation to their reports back to them. And I take that role particularly seriously. It's not a role that is delegated. I read every one of the reports that comes back and make a decision on whether I have any recommendations or comments to make. And I have used that provision, but it is only rare. If there is a circumstance in which I believe, given the investigation that has occurred, that something further could be done in relation to the investigation that is reasonably proportionate to the investigation and the allegation. So that's a very important process that we have. But I think probably more important is the work that Mr Ratcliffe's team is doing in this agency investigation space. So in effect, we don't need to get to that recommendations point too often, because they're having meaningful conversations throughout the investigation about how the investigation's going, what further steps need to be taken, whether it's come to a point that it should actually come back to ACLI to investigate, or investigate jointly with the agency so that they can utilise some of our powers at that time. Mr Ratcliffe, was there anything further you wanted to comment on that?
No, I think that covers it off, Commissioner.
Thank you. So I could take it from that given the collaborative approach and the ongoing dialogue with each agency, you'd expect over time the consistency of quality of all the reports to be on the up, meeting your expectations.
I think that's right, Chair. And I think there will always be some agencies that will have more matters than other agencies. So there is, of course, if you've done more investigations and written more reports, it's highly likely that you'll be more skilled at that. There will be some agencies, given the nature of both their roles and the application of the law enforcement test, where I don't expect to see large numbers of referrals coming from them. And so they will have less opportunities to develop some of those skills, and we'll work closely with them in relation to their matters.
Now, Mr Conahan is having some technical difficulties, but so he's asked me to, one, give his apologies, and secondly, to ask some questions around patterns and trends in corruption and how you're responding to them. So given we're about a year and a bit into the new agencies and a new suite of agencies, has there been any significant trends in behaviours identified, corrupt behaviour or otherwise, that has come to you in your oversight position?
So the numbers with the new agencies are very small, so it's particularly difficult to pull out any noticeable trends yet. So last financial year across the 4 agencies we had 12 matters referred to us. This financial year so far across those agencies we've had 21 matters notified to us. The types of things that we're seeing are similar to the types of things that we see across the board. It's unauthorised access to systems, abuse of office, bribery and conflicts of interest. I think that's what I probably expected, and that's the type of things that we're seeing at the moment. I'll just ask, Ms Atkinson has the corruption prevention area in her space. Is there anything further you would add to that?
Commissioner, I think, I mean, just to reinforce the point that the Commissioner's made, I think the types of vulnerabilities that we identify right across our jurisdiction are kind of common, regardless of which agency we're looking at. And I think for that reason, the Commissioner this year has decided to publish her vulnerabilities brief for the first time and make that available sort of more broadly, and very much consistent with the matters that have been notified in relation to the new agencies. I think the misuse of information or abuse of office in relation to decision making are kind of key risks that we would see across public sector agencies as vulnerabilities to corruption.
And is that tying into your corruption prevention strategy work, which I think is mentioned in the annual report?
That's right, Chair. So we have also just finalised our new corruption prevention strategy, and I think you'll see in that strategy that our focus is really on leveraging the good work that is going on across our jurisdiction. So you would have heard in the discussion with agencies in relation to your other inquiry, some of those agencies have very sophisticated corruption prevention capabilities. And I think the value of being able to bring together that expertise and knowledge and share that amongst our agencies is significant. We're also working very closely with other parts of the public sector that play a role in relation to corruption prevention more generally. So the Commonwealth Fraud Prevention Centre within the Attorney General's Department, for example, the APSC's new academy, which the Commissioner is on one of the integrity chairs for. I think the value, I mean, ACLE's corruption prevention capability is still quite small, but we see a lot of value in bringing together those insights from our investigations and then utilising the expertise of the other agencies that we're linked up with.
Just to move to a different topic, Section 142 of the Act operates in requiring you to refer matters to the Commonwealth DPP. Does that section, in your view, provide you as Commissioner with appropriate levels of discretion in relation to referring matters, including non-corruption offences?
Thank you, Chair. I was fascinated when I read through the Act just after I was appointed to find Section 142 because I'd not seen a provision like it. And of course, I've come from a CDPP background, so I was well aware of the prosecution policy of the Commonwealth and the framework in which Commonwealth prosecutions are undertaken, which is that the investigation is a matter for the investigation agencies and the referral of a brief is a matter for investigative agencies to decide whether or not to refer. And once a brief's referred to the CDPP then makes the prosecution decision based on the prosecution policy of the Commonwealth. I'm in a slightly different position as the Integrity Commissioner because Section 142 mandates me to provide a brief of evidence or assemble all the evidence either to the AFP or to a prosecuting agency, which in the Commonwealth would be the CDPP, where an investigation has led to me obtaining evidence of an offence against the law of the Commonwealth that would be admissible in a prosecution of an offence. I read that provision as requiring me to be satisfied that the evidence available is admissible evidence that goes to each and every element of the offence, so both in Commonwealth Code terms, the fault element and the physical element, or each of the fault elements and each of the physical elements of the offence. I must have admissible evidence of each of those. But once I have that, regardless of the offence, it doesn't need to be a corruption offence, it can be any offence, I must assemble that evidence and either give it to the AFP or to the CDPP. As I say, that does put me in a different position to other investigative agencies, and I can foresee the potential for that leading to a situation where in the course of our investigation for, say, a serious corruption offence, we didn't find evidence of a serious corruption offence, but did find evidence of another offence, possibly a trivial offence. I would be required, if I had evidence that went to every element of that offence, I would be required to refer that brief rather than have a discretion to choose not to. That then has an impact on my resources. It has an impact on the CDPP's resources. They must assess the brief. I must continue resourcing that investigation while the brief is assessed and possibly prosecuted. So it does have some consequences, and it does make, I think, my staff particularly vigilant about the requirement that we must refer a brief if we have admissible evidence. And so that is on my investigators' minds, and it's on my mind. Whenever you see a must in legislation, you take it very seriously, and I do take that very seriously. So it is, I foresee that it could possibly have unintended consequences in relation to referring a brief on a matter that I would not otherwise refer a brief on.
In a slightly different perspective, is there a risk of double handling? I mean, in essence, there are going to be a brief to evidence going to an organisation that, in its ordinary course, prepares a brief of evidence. Let's say an investigation from the AFP on a completely unrelated matter, and you get lawyer-on-lawyer views of whether all the heads of the offence have been met, and then a subsequent, effectively, review of your brief of evidence to decide whether they want to go on. Leaving aside whether I'm making the assumption the witnesses are all up to proof and all the rest of the things that are required pre-trial. Have you had any reflection on that?
We would normally, as is the case in the Commonwealth, we would normally refer a brief to the CDPP rather than, we do occasionally arrest and commence proceedings that way, but even when we arrest and commence proceedings that way, we then go through a process of referring a brief to the CDPP or the prosecuting agency. We don't prosecute ourselves. There are some Commonwealth agencies, a small number that do, but we don't. So we would normally refer a brief anyway, so you would have that consideration of the brief by the prosecuting agency, which I think is a good thing. I have seen that there have been times in the past where ACLI has assembled the evidence and sent it to another investigative agency like the AFP. I suspect we probably wouldn't do that in the future, except for a case where, for example, we were investigating a matter and in the course of the investigation we saw some other offending. One that comes to mind that could happen is you're investigating corruption. In the course of that, you also see evidence of money laundering. Money laundering is not in my remit. Corruption is in my remit. And if I couldn't see a connection between the money laundering and the corruption that I was investigating, we would probably send that information through to another agency, but it wouldn't be a finalised investigation. It would be sending something to them for them to then go and investigate. So slightly different from the 142 scenario.
There are various models of integrity bodies around the country, and there is a school of thought, and I'm not putting this forward as my personal belief, but that integrity bodies should simply investigate and prosecution authorities should prosecute. But there are various models which are almost hybrid in the fact that the Integrity Commissioner can almost refer it to investigate it, prepare brief, arrest and charge. Now, I understand your evidence, you have certain powers, but you're also, your general disposition is to refer off to the DPP, which gives us sort of almost a separation of powers and review. But have you given any thought to
So
the veracity of those models? Or, because I can see from your answer, you generally prefer a model where the DPP can take a sort of independent view.
And I'll be really clear, Chair. I come from a CDPP background. I spent 15 years as a criminal lawyer in the CDPP. So I have to be aware that is my frame of reference. And the Commonwealth's, just like integrity agencies or anti-corruption commissions in each of the states and the territory and the Commonwealth is different, so too are the prosecution regimes in each of the states and territories and the Commonwealth. We align closely with the way that prosecution works in the Commonwealth. In the Commonwealth, the CDPP carries a summary and an indictable jurisdiction, and they conduct most of the prosecutions, except for a very small number of agencies that conduct their own minor summary matters. So we align ourselves and operate, and our Act enables us to operate in the same way as other Commonwealth law enforcement agencies, save for Section 142, which mandates me to send a brief whenever I find evidence of a criminal offence, rather than having that discretion. Not a discretion about whether or not I would do it myself, but a discretion that I must send a brief if I have admissible evidence of an offence.
Thank you for that. Have you formed a view on the definition of corruption? Is it, in your practice, too narrow, or any merit in the arguments that it should be reviewed? Does it bring in too many lesser offences? I mean, I appreciate this would be an ongoing view and one which is evolving, so I don't particularly wish to, get you to have your answer set in concrete, because I imagine it's part of the journey. At this point, do you have any reflections you'd wish to share?
I would say that our definition is quite broad for corruption issue, which then relates to engaging in corrupt conduct. It includes conduct for the engaged in for abuse of office, conduct that perverts the course of justice, or corruption of any other kind. So we have quite a broad definition of corruption. That corruption of any other kind part to the definition is particularly broad, and we've done some work over the past 2 years to think about what's really encompassed by that part of the definition, and when will matters fall within that part of the definition and are not. One of the things that we've thought about, particularly given how broad the definition is when we receive notifications and referrals of matters that may fall within the definition of corruption issue, whether it's appropriate for all of them to stay within the framework of the Act because of how broad the definition is. So, for example, we consider that browsing falls within the definition of corruption of any other kind, and yet you can have allegations of browsing of systems which are quite minor and are properly dealt with by agencies through their code of conduct or through warning letters, and don't need, in my view, to stay within quite a regimented framework like the Leak Act. And so Miss Lind and her assessments team have done quite a bit of work in thinking about what matters may be corruption issues, but which we would decide to take no further action on at assessment, because we know that agencies are going to deal with them through their code of conduct procedures. What matters are corruption issues but are appropriate for agencies to deal with, and what matters are matters that really should be investigated by ACLI. Ms Lynn, do you want to add anything to that?
Only to say that a public-facing assessment policy was finalised last week. It's on our website. And factors that are taken into account is the severity of the allegations of the offending, whether it's current and ongoing, whether it's historical. What's the risk for the organisation? Does the person need to be stood down immediately given the risk and severity? Or is, as the Commissioner said, this is a relatively minor matter of abuse of office through, looking up information, protected information, that you've got no business need to do so, and it's quite confined in its severity and can be dealt with as a code matter, not as a corruption matter. But happy, we'll be engaging with our agencies over the coming months to go through that policy in detail. It's designed to provide much greater transparency as to what's in our mind when we make assessments of corruption issues, and importantly how we should deal with them.
Thank you for that. Does any other committee member have any questions at this stage?
Chair, it's Tony Zappia. Perhaps one last question from me to the Commissioner.
I'll go to you, Tony. Mr Zappia, I'll go to you now.
Sorry?
I'm giving you the call. Apologies.
Okay, thank you. Thank you. Commissioner, in your time as Commissioner, have you been able to identify any constraints to your ability to investigate matters that you believe need to be addressed by government? I guess I'm asking whether there's any processes or any restrictions in legislation that are preventing you from doing your work even more efficiently and more effectively.
Thank you, Mr Zappia. That is a very good question. I think that what I would say is in the last 2 years in my time as being Integrity Commissioner, my focus has been on both in bolstering our internal processes and governance, in making sure that we continue the important investigative work that we're doing, and bringing on the 4, now 5 new agencies that have come into our jurisdiction. I've been given a wide range of powers in order to do my work. I've been very clear about that we will use those powers proportionately, and that we will ensure that that we are using those powers in the correct manners, including in relation to our powers under the Telecommunications Interception and Access Act. In my 2 years of being here, there's nothing that I have seen so far that has inhibited me in my fairly narrow lane of corruption in relation to law enforcement agencies. There are the issues that we've discussed this morning about working through how the law enforcement test works for the 4 new agencies, and some unforeseen consequences. We will continue to operate within that regime because that's the regime that has that is before us, and those matters which do not fall within our jurisdiction, but which we see criminality, we will refer on to other agencies to investigate. There's also, just in the back of my mind, there's always issues around new technology and about how that works, and our own capability to be able to access this and use it. I think that's an ongoing conversation for law enforcement agencies. We still use telecommunications powers extensively within our investigations, but you will have seen the conversation over the last few years about a movement by serious and organised crime away from some of those, away from using devices that can be picked up using some of those powers. That was seen through the Operation Ironside work that the AFP did, and we are conscious of the new powers and the new ways in which serious and organised crime might operate, while also being conscious of the fact that we are a very small agency and we need to rely on other law enforcement agencies for some of our capabilities. Mr. Ratcliffe and Ms. Lind, has there been anything that's come to your minds in that space?
I think just in relation to your last point, Commissioner, we play an active part in the working groups and the interagency groups who deal with those sorts of issues around how we combat the new technologies and modes of communications. So while there's nothing specific, we're still very much part of the group of agencies who are working towards always ensuring that we're keeping up with that technology.
Chair, thank you for that, and Commissioner, thank you for your answers. That's all I have. Thank you.
Thanks, Mr. Zapier. I have a question regards, I noticed in your organisational chart there's no Deputy Integrity Commissioner. So could you explain what acting arrangements apply when you're not available?
Thank you, Chair. This has become an issue of some discussion for us. So when I began as the Integrity Commissioner, I asked for an acting arrangement to be put in place that relied upon deputy officers from other oversight agencies, because there wasn't and isn't within my organisational structure a deputy position. So the current acting arrangement provides for three named people: the Deputy of the Inspector General of Intelligence and Security, the Deputy Ombudsman, and the Deputy Information Commissioner are named within the acting appointment to act in my position if I'm away for 5 or more days. We have made that acting arrangement work for the last 2 years, but it probably is not sustainable over the long term. Also, given the size of the growth in ACLI and the growth in our jurisdiction, it is probably time for us to think as an organisation about having a Deputy Integrity Commissioner for the ongoing sustainability of the organisation, and I'm in discussions on that point at the moment.
Does any other committee member have any questions? I might just finish off with this one. If you just summarise from your view key challenges for the coming year.
Thanks, Chair. I think that the last financial year was a particularly big year for ACLI. You'll have seen that we had the most notifications we've ever had. We've assessed the most matters. We've provided the most reports to the Attorney-General. We did that while doubling in size and while dealing with the COVID pandemic and working from home at various points, which also did impact on some of our investigations and some of the work that we could do. So we have come off a very big financial year. We have proved and what we are able to achieve as an organisation, and I'm very, very proud of the work that we did in 2020-21. Looking across to this financial year and the year ahead, it's a time for us. We've done a lot of work in relation to our policies and procedures and our governance and our structure. It's a time for us to ensure that those are all embedded and they're operating properly. Just as I said in relation to our KPIs, it's a time for us to, we've put these things in place to make sure that they're operating as we expected that they should, and that we're using them properly. We also have a range of important and interesting investigations on foot. So the challenges ahead are to make sure that we keep on going and we're doing the work that we need to do in a timely fashion, and all evidence is that we are. We need to ensure that the work that we have done with the new agencies continues, and that they those relationships continue to mature and grow. And we need to be ready for the implementation of the CIC in whatever form or whenever it may be legislated. I see that ACLI is the organisation in the Commonwealth on the ground with experience and understanding of being an anti-corruption commission, and that we will play an important part. And whatever we can do now to get ourselves ready for that, we will be doing.
Thank you. Of the last casting, does anyone else want to ask a question on the committee? All right, that concludes today's proceedings. Thank you for your evidence and coming in twice today. The committee has agreed that any answers to any questions taken on notice at today's hearing will be returned by Monday, 7th March 2022. I thank the witnesses for the evidence to the committee today. Commissioner and your staff have been very generous. Thank you also to Hansard Broadcasting and to the Secretariat staff. I declare the hearing adjourned.
Thank you.